Ensure your tray backs are fixed securely to the seat in front of you, and make sure your seats are in a vertical position. You are leaving the ordinary and entering the court gallery. It's me, your local foosel, the guy who scours YouTube and looks for interesting cases to watch every day of the week, sans Sunday. But ladies and gentlemen, I come to you with an extra long Saturday weekend edition of our normal everyday show, because we have some very long cases. We're going to start off with Judge Goggins. He's got a lady in front of him who, she had a contract with some landscapers. She didn't think they did the job quite right. So what you gonna do? You're gonna do the same thing everybody else does. You're just gonna kidnap the landscapers. You're gonna keep them in your backyard until they finish the dadgum work, right? Well, that's gonna end up in court. And it did in front of Judge Goggins. We're gonna watch that. Then we're gonna go see Judge Simmons, who has to deal with a public defender who has a client who doesn't want to communicate and has a tendency of headbutting his romantic partners, contrary to the law. And then we're going to go to Judge Simpson's room, where an upstairs neighbor is very unhappy with a noisy door, and Judge O'Donnell's got a bunch of messes to take care of, and it all starts right now.
How about Trustworthy Lawn Care versus Sharon Ma? Anybody in that matter?
Yes, I'm here, Your Honor, for Trustworthy Lawn Love.
Okay. How about Sharon Ma? Do I have Sharon Ma? Sharon Ma is there. Just need him unmute. It's Ma. Just got to unmute there for me. There you go. Are you there?
Hi.
Hi. Gotcha. That's... So here, see, for Trustworthy seeking $6,560.17.
Your Honor, I apologize, but I can hardly hear you.
Okay, I'll try to speak up for you. They're asking for $6,516.17.
I have no idea where that figure's coming from.
Okay. Void says that you signed a contract.
I signed a contract for $2,712.79.
Okay. Well, we'll get to that in just a minute then. So, Ms. Beckett?
Yes, sir.
Is that correct? That's what you got in your complaint. You're asking for $65.16.17?
Yes, Your Honor.
Okay. Do we have a written contract someplace?
Yes, Your Honor. I emailed it over to you.
Okay.
I think her name is Janet. Printed it off for you.
Yep, I think I got it here. Looks like it. Okay, why don't I guess both of you raise your right hands for me. Ms. Beckett, can you get on video there for me? There you go. Can both of you raise your right hand? Do you swear from the testimony you're about to give me the truth?
I do.
Yes.
Okay, all right. Ms. Beckett, and how are you an employee of Trustworthy Lawn Care, or do you own it, or what's the relationship?
Yes, Your Honor. I'm the founder of the business.
Okay. So you're familiar with the books and records as it pertains to this matter as well?
Yes, sir.
And I did receive from Trustworthy, it looks like it says estimate number 294, total $2,712.79. It breaks down what was done. Backyard dirt, backyard leveling, backyard grass material. There was a discount for being a new customer, process credit card, fee for credit card, and looks like that's how we came up with the total. Was the work completed, Ms. Beckett?
It was almost completed, Your Honor. So we serviced her on September 7th was the scheduling day.
Okay.
Actually, I think it was a 6th. I think it was a Saturday and a Sunday. Let me look at the calendar real quick.
Okay.
September. Yep. The 6th and the 7th of September of 2025. She was scheduled to have service done. I had 3 employees on the 6th go out and with all my machinery and equipment, they started servicing her. They started moving the dirt. Her and we were on the same page when I wrote up the quote, which turned into a contract because she signed it.
Okay.
So we were supposed to use most of the dirt that was there. She had a pool installed, so she had a lot of leftover dirt. So I suggested, why don't we use most of that dirt, level it out, we'll bring in some topsoil, we'll grass seed it, put the straw down, etc. And she agreed to that, obviously. Was very happy with the amount of money that she had to pay for the amount of work that was supposed to be done.
Okay.
I had my employees stepping aside, calling me, saying Miss Mott was harassing them, continuously coming out, screaming at them, telling them that they don't know what they're doing, they're using the wrong machines. The owner of the business doesn't know what she's doing. She's got the wrong machines, et cetera, et cetera. I apologize for them because I wasn't near that scene. I couldn't get there to help them. So I told them to have Miss Mott call me so I can figure out what the problem was, why she was screaming at 3 of my employees. So the manager of the business that managed that at the time told Miss Mott to give me a call, and she did, and she was screaming at me on the phone. I did calm her down, and I was like, I'm not sure what is going on. And she said, they're doing it wrong. She just, from what her and I had negotiated with the contract, she completely turned a whole 180. So I told her that I would send her out a new contract because that voids the current contract due to she signed it. She's not supposed to be. I understand it's her backyard, but per my contract, due to the past and other, customers, she's not supposed to be in the area with my employees working. If she has a problem, she had my number. She can call me, contact me. To not, it is in the contract towards the very end. It states stay off the, area of where employees are working. So, I told her the contract's void, that I would send her out a new quote because she wanted all of the dirt removed instead of it still being level. It was almost level, but we didn't get most of it leveled. And the way that we were doing it wasn't to her standards. Like, we multitask. She wanted, section A done, then section B, and then section C. And I said, well, that's just not how we do it. We've been in business for a few years. My guy's been doing landscaping for over 10. Like, I trust him. She was very discriminating with my employees on being very uneducated, etc. So I sent her out a new one, and she said no, she doesn't want to pay that price. And I said, all right, well, we'll be out there on Sunday. So myself, as well as my manager that was there the day previous, his name is Eric, we went out to her property, and I was trying to speak with her. She had a gentleman on the property. I wasn't sure who he was. He was holding a stick sitting on my hay barrel, or straw barrel, telling me I was using very volatile words, not being very kind or polite. So I said, you know what? We're just going to grab our machine. We're going to part our ways because, Miss Mott, you're not following, you're voiding your contract. Like, this isn't happening. They were being very, very demanding, we'll say, kindly. And so I told Eric to get the machine when I did so, and I do have proof. She locked Eric and myself into the backyard and held us hostage. I have video footage. I had to call 911 due to the fact that she was not letting us out. Eric took my dingo and rode up to where they were standing in front, and I found out that the other gentleman, I don't know his first name, I think it was Rob or Robert, I'm not sure. He identified as Miss Mott's brother. So Eric was with the machine asking them to please move, that we just want it to load up. At the time I told her, I'm like, I just want to be out of this. Whatever's owed is owed. You canceled your contract, you're holding me hostage, and she didn't care. She again used horrible words, very bad language, told me to call the police. I did so. So we were stuck in the backyard. Eric did try to get off the dingo to ask, them to move. In the process, her brother put his hands on my manager's throat and started choking him. Eric pushed him away. Eric went to go pull his fist back to punch him, and I said, please don't, please don't. I knew he was in his 70s, so doing so wouldn't fix anything. Eric listened to me, thank God, got back on the dingo, came back to me. I was on the phone with 911, screaming, crying, please, please, please. They asked if she had a gun. I said, I don't know. She went back in the house. To be completely honest, I don't know. This world, I don't know Miss Mott from you, Your Honor. The police came out. When they came out, she and her brother were still guarding the door, not letting us out. They had to fight with her, and she told the cop to fuck off, that we weren't leaving the property until we finished what we started. The cop said, well, this is going to be a criminal matter, and pushed her out of the way and opened the door. So we were there for a little over 2 hours. Per the contract, I only charged her for I and Eric being there for 2 hours, even though it was over 2 hours. I could have charged her for more, but I felt that the extra $2,000 for holding us up and, holding equipment, us not, being able to get out. And so, anywho, I sent her the final notice. She failed to pay for the contract after 3 days. You can run the credit. I ran partial because at the time I didn't have the $2,000 on there, because I'm like, well, if she pays, it is what it is. It's washed. We're done. We're safe. Mentally it wasn't okay, but physically thank God we were okay. I ran it, and then she disputed it, and it came back. So that $1,266.05, the partial payment, she refused with her credit card, so that came back. So she had a huge lump sum that she owed. Per the contract, she owes a 25% annual compounded interest as well as late fees, and that is what you'll see on the billing of October 20. The late plus the monthly compounded interest. It's combined together at, I think, 11.666667% of the final bill owed, and she refused to pay it, so it keeps adding up until here we are.
So let me just kind of step back. So we've got the original bill that was the 2007 1279. Is that right?
2007, yes, sir.
That was the original contract, and if that had gone smoothly,
Correct.
that was the amount.
100%. You
Okay.
got it, Your Honor. Yes, sir.
Okay, and then the second one, though, looks like I've got that attached too. Shows a total $8,093.92. And let's see, okay, I see where the extra 2,000 was for the 2 hour
You got it.
extra hold up there. Okay.
Correct.
And then got the backyard. That looks like it's probably all the same. I guess. Yep. 1525, 525. And we've got it says late payment, 10% per signed contract. Is that
That's the first initial late payment, yes, Your Honor.
okay? And that's in the contract. If I look in here, I will, but if I
Yes.
look in the contract, I'm going to see 10%
Yes,
for
Your Honor.
late. Yeah, okay. And then open invoice. Over late. Help me out with that. It says October 25 late plus monthly compounded interest. Help me out with that. How do we get that?
Yes, Your Honor. So that's the 10% for the late fee for non-payment, and then the monthly compounded interest, it goes 1.666667% each month to add up to the 25% compounded annual. So if you divide that by 12, it comes up to 1.6666. So together, I believe it's 11.666667% each month that she fails to pay. Obviously, the payment adds up very quick when you owe a lump sum and fail to pay. And that's how it became the $8,000. When I filled out for this court date, she owed the 65 and some change. I'm guessing that was, I think, October, November, December area. It keeps adding up. So that's last court date when I asked you for the 8,000. That's what you didn't understand. And I told you the compounded plus late fees add up when you owe a lot of money.
What work was not completed? I understand that whatever the hindrance is, what work was not completed on the job, though?
It would have been completed if she would have let us. Yeah.
No, I understand, but what was not completed?
She wanted, so she said it was level. I do have video footage and pictures of that, and it was not level. So she said that it was level enough, and she wanted us to take a lot of excess dirt away. And I had quoted her for maybe like a trailer load of dirt in the beginning when I told her, I said, most of this dirt, I said, without, this is an estimate of doing this for many years. I said, you'll have maybe a trailer or less load after we get it leveled, maybe even no dirt. And she said, okay. So what she was complaining to my employees and myself the day that she called on Saturday, September 6th, was she wanted no more dirt pushed back towards the back area of her property. It was in the back left area was where most of the dirt was supposed to go, that she just wanted it removed immediately. Like, just take it all. And I said, ma'am, that's like 3 trips or so with a big dump trailer. I said, if you want me to do that, I can. I said, that voids this contract because you're not following what we were supposed to do. Like, you're totally changing paths, which is fine if that's what you want to do. I said, but that calls for different equipment. So I gave her a different quote because I needed a different trailer. Like, I had to go rent a bigger trailer. I don't have that size trailer. And then the dumping fees, et cetera, et cetera. And I would have had to get a bigger machine as well because it was, some hard clay, is what I was going to take out of there. So she refused, and didn't want that done. So when we showed up on Sunday, I was actually going to finish it myself. That's why I showed up myself. Because I just couldn't believe, because when I met Miss Mott the first time, she was a very kind, very passionate, very lovely lady. Like, I didn't see any red flags. I didn't feel any bad vibes. So when I showed up on Sunday with Eric, we went to the backyard, and Miss Mott was just not who I met the first time, and was not pleasant, not letting me leave. And so things just didn't go according to our contract. And she wanted things done a certain way under this contract, which was not the right, she didn't want it done that way. She didn't want to pay what she wanted. She wanted things done her way on her terms. And I'm like, that's, unfortunately, I run a legit business. That's not how we do things. Like, I tried for about 15 minutes to try to calm Miss Mott and her brother down. And then when I realized it wasn't going anywhere, and I wasn't calming them down to try to make sense, I listened to them. That's when, they literally stood in front of the doors and I guess the fence to be able to get out, both of them.
So
Sadly.
let's kind of talk about the excess dirt then.
Sure.
That was way in the back there. How much was that charge to take that out? What was that going to be? Did you talk about a figure with her at all?
Yep, I sent her a quote, and she denied it and said no. So let me look up.
Or actually, and maybe it doesn't matter. Was it just left there? That dirt was left there then?
Yes, the dirt was left there.
Okay, so maybe we don't need to make that an issue. She said no at whatever figure you gave her. She said no anyways.
Correct, Your Honor. Correct.
Okay. So how do we help me out with the 2 hour extra time period that you're delayed with your employees back there? How do you come up with the 2,000?
So it's $500 per an hour. There was two of us. So you take 2 times 4 hours is $2,000.
Okay, so we had two for two people.
Correct. For myself and Eric. Yes, sir.
Okay. And I'm sorry, Eric's the one that was doing the work.
He was, yep,
at that
he was the
point?
one that was managing the landscaping project on Saturday.
Were you doing any, I just asking, were you doing any work or were you just coming out just to talk to her?
I was going to try to finish. Yep. I was going to try to finish. That's why I was talking to her. I wasn't expecting her brother. I really crossed paths with him first. He was very not polite, and I just politely said, I don't know who you are, but I'm going to talk with Miss Mott and figure out what we can do. Like I said, I tried to negotiate with her. She was very not happy. She said it was already leveled, and I said, no, ma'am, it's not. Like, you could see it still has a small dip. We could still use more dirt. You already, yeah. So I did try. After 15 minutes, when she looked at me and said, "You're not leaving my property," that's when I kind of had a red flag pop up and say, "Interesting choice of words that I'm not going to be able to leave your property."
Okay.
And that's when
Has there been any criminal charges filed or any
To
prosecution?
be honest, I'm not sure, Your Honor. I tried to get the police report, and they told me that I wasn't on it for some strange reason. Seems how I was the one that was there the following day. I was the one that called 911. I was the one that gave them all the recordings of her holding us hostage in the backyard with her brother. I'm not sure. So I did talk with not the prosecutor. I'm not sure who the gentleman's name. I think it was Mr. Burnett. It was close to Beckett. And I spoke with him and told him, everything pretty much that I told you. And said I would like to be on it because I was, I'm the owner of the company. I'm the one that would like to prosecute her. I'm not sure if it did or didn't. So I don't know.
Okay. Did you personally do some work at that point at all on the property?
No, Your Honor. I had 3 employees previous that worked, I think, 10 hours the first day, 8 or 10 hours. I don't know off the top of my head, but roughly that long on a Saturday. And then I went back on Sunday to try to finish up with Eric because my employees were, I'm not going to lie, they told me that they weren't going back with Miss Mott, that they were scared due to the hostile verbiage that she was continuously giving them. They didn't feel safe, and I told them absolutely that I would do it. And Eric, volunteered to go with me because I at least wanted somebody with me, to be honest.
But you were there with your equipment is the big thing.
Correct. My equipment stayed on her property overnight. Yes, sir. Yep. So it stayed on the property because we were planning on finishing.
Yeah.
So when I went back on Sunday, we were going to finish, and Eric hopped on the dingo, and that's when she looked at me and said, "You're not leaving my property," which I thought was choice of words. So I threw my hand up and told Eric to stay there, and that's when her and her brother walked over to the fence and locked it and stood in front of it. And that's when I had to call 911.
So the amount that you're going to sit now. The 6,516.17 that you're asking for, then you've got the original contract, 2007-1279, but we had a little bit of work that wasn't completed. Sure. I understand there's a little bit more to it, but
yeah, sure.
How much work on the original contract was not completed then? Was it just
she had about 80% of it done. There was about 20% left. I just had to, push more dirt, and half of I believe about half to 75% because it was let's say it's a square, right? And then about a quarter of the square in the back left corner needed to be filled with dirt, and she wanted the grass seed and stuff. So one of her main complaints was when my gentlemen were pushing the dirt, because I had 3 people there. So I had one pushing and one, they were all doing something different. So by the time, so they were working to the right, to the left quarter. As the dirt, like the right-hand corner was filled, I was having my other 2 employees put, by hand and shoveling with one of my other equipments, putting the topsoil down, making that a little bit more. And then I had my 3rd one putting the seed and the straw on it. So we were working as a group, and that was one of her, and that's fine because that's who she is, but she wanted the dirt complete first, then the topsoil, then the grass seed, then the straw. And I'm like, well, that's not how we do it. And she said, that's not how I want it done. And I'm like, unfortunately, in order to be time efficient, this is how I've always done it. And that was one of her main complaints when she had called me, that I don't know what I was doing. I was using the wrong equipment. My boys are stupid. They're useless. They're standing around, et cetera, et cetera. I'm like, oh my gosh, like they've worked with me for a couple of years. I've never had problems. I've always had compliments, but I took it into consideration, talked to my guys, and they said no. Like I said, they weren't comfortable even going back to Miss Mott's house. That's the reason why I did on Sunday, because I'm like, well, I'll just finish it up. I mean,
So,
what's there to be afraid of? She seems like a very nice person, but
okay. So when you say 80%, really, since you can't really tell me one particular part of the job wasn't done, it was just basically 80% was done with all this type of work done. Is that what you're saying?
correct.
Yeah. Okay.
Correct. Yep. So I needed to push a little bit more dirt and lay a little bit more topsoil and grass seed and stuff, and then take a small pile of dirt away.
All right, let me hear from her first. I may have some other questions for you as well. First of all, Ms. Mott, do you have questions for Ms. Beckett?
No, Your Honor, but I would like to tell my side of what actually happened, if that'd be okay.
Yeah, I'm going to give you just a second here. Why don't you raise your right hand for me again? Oh, again, well, I already swore you under. You understand you're under oath?
Yes.
Okay.
Yeah.
All right. You can go ahead and
I'm
testify.
kind of wondering if Holly remembers that she was under oath, but that's beside the point.
Okay.
So I signed the contract with Holly on August 20th. And again, that was for a grand total of $2,712.79. I provided a cash deposit to Holly on the 24th of $1,350. They began work on 9/6 per the contract. And I'm assuming, Judge, I think I heard that Holly did send you the contract, so you have a copy of that?
I do. It looks like I do. Yeah.
Okay.
It's got your signature on it.
So the first line of the contract is removal of a massive, those are her words, pile of dirt. There was also a pile of sand, and the sand was going to stay. So just to give it some context, Your Honor, there was a massive pile of dirt in my backyard. We talked about removing the dirt. That was key. A little bit of the dirt was going to be used to fill in by the fire pit. That was like a dip in the backyard. And she was going to spread that dirt out, topsoil, seed, and cover it. So on the 6th, they probably moved, I would estimate roughly 5 to 6 yards of dirt in a circle, continuously in a circle all day long. The topsoil that got delivered was delivered to the street. It was getting late, and I went out and said, guys, the topsoil, I don't know if you're ready for it yet. I think you are, because you've got enough dirt spread. The rest of the dirt's got to come out. And the manager said, well, we really aren't planning on taking any dirt out. We're going to spread all this dirt around. Per the contract, Your Honor, clearly she planned on removing a massive pile of dirt.
Well, just point to me right there. As long as you're telling me that right now, point to me in the contract where it says she's to remove a massive amount of dirt.
That's the first part of the quote, the very first line of the quote. This is what I signed.
I see under the listed part. I gotcha. Remove.
So the top part is the detail of all the work that I contracted with her to do.
Okay.
So even though they weren't ready for the topsoil, according to Eric, they did move all of the topsoil into the backyard because they couldn't leave it on the street all night. It took well over 2 hours for them to move 5 yards of topsoil into the backyard. To give you some context for how long it took for them to move a small amount of dirt. So I did contact Holly at least once on the 6th because I was concerned about the incline of the yard. The back of our yard slopes to the house. And when Holly originally came out to quote the job, we talked about that incline, and I didn't want to increase the incline because obviously with snow and rain, it's all coming towards the house. That's why it was very important that the dirt leave, and only a small amount was going to use to be level where the fire pit was. So when they came back out on the 7th, I was actually not sure they were coming back out. It was after 11 when I reached out to Holly and said, "Hey, are you coming out?" They came out, and Holly was a different person. I don't know. I'm not going to go into the detail like she accused me of, but Holly was not the same person that I met when she quoted, that I met when I gave her the cash deposit. And very abruptly, after a short while being in the backyard and emphasizing to her that the dirt needs to leave my backyard, it can't stay because of the incline towards the house, she said, "Mrs. Mott, I can't work with you." And that's when they decided they were going to leave, and we did prevent them from leaving. And hands did get put on my husband. It was not my brother, and he is in his 70s, and he had a back injury and could hardly stand. That's why he was sitting on her hay bale with a broom handle, because he could barely stand. So to summarize, Your Honor, the balance was $1266.05. I didn't pay the balance because I had over 15 yards of dirt still in my backyard. 2 places in the contract that I signed specifically states the total remaining balance is due when work is completed. Work was never completed. I don't think I owe the $1266.05. As a matter of fact, the $1350 that I did pay Holly as a down payment, when you looked at my backyard and the cost of the topsoil and the fact that she didn't even have to pay for the skidder, she borrowed the skidder, I think $1350 was actually excessive. And I was thinking about taking Holly to small claims court to get part of my deposit back based on the amount of work she did. I have subsequently had to hire another company. It was Ace Outdoor Services, who did come and complete the work, remove the dirt. It was more than 3 dump truck full. It was, the guy from Ace said it was roughly 17 yards of dirt that he removed. That was dirt that she was supposed to have removed from my yard. It's the first line on the contract, Your Honor. That was the key, and she didn't do that. And based on conversations I had with her manager and her, they thought they were just going to spread all the dirt in my backyard. That was never agreed to. Obviously, on the quote that I signed, a massive amount of dirt was to be removed from my yard, and she had no intention of doing that, although I didn't know that until the 7th.
I'm sorry, until when?
Until the 7th, when she decided she could no longer work with me. And, you know, at the end of the day, she left me with 18 yards of dirt in my backyard that she was supposed to remove, that I contracted with her to remove.
She's telling me that you were preventing her from removing that dirt in the back at one point.
That is true. I did not know that we couldn't legally do that. And the cops did explain to us that we couldn't legally keep them from removing the equipment. So yes, I do admit I did that. And I'm waiting for charges to be filed. We did go to the police station for a copy of the police report. It's going to cost a ridiculous amount of money for the police report. That right now we contacted an attorney, and the attorney said he will be surprised if this actually gets prosecuted, and said, don't bother getting the police report. Let's just wait to see how things pan out. So we're sort of in a holding pattern. And then I got a notice about small claims court. And by the way, I never received any other bills from Holly other than she fraudulently, in my opinion, tried to take the balance. And then on September 20th, she tried to take another $3,800. That was her second contract that she wanted me to sign, that I said, no, Holly, I'm not doing that. Let's just stick with the original. Let's get that work done. The second contract was to seed around the pool, and I wasn't going to do that with Holly. So that's where the $3,800 comes from. That was never signed by me. That was never agreed to by me. We're dealing with one agreement with a total cost of $2,712.79. The balance owed, I did dispute the charge. Capital One investigated, found in my favor, did not pay Holly, and credited my charge. And the second time she fraudulently tried to take money, the card was locked, so she was unable to take it.
Okay, I'm sorry. So explain to me when I guess you put a
I'm sorry, Your
hold
Honor,
on
I
your
can hardly hear you.
You put a hold on the charge on the credit card charge. Is that right?
Yes, I disputed the charge, and the credit card company investigated it and found in my favor.
Okay, so well, yeah, whatever they did, but what did they hold back? What was the amount that they held back then?
She tried to take, the credit card company was charged $1,266.05. And that's the charge
Okay.
I disputed.
That was the original amount.
Yes, that was the original singular contract that I signed.
So as of right now, and I just want to make sure, so as of right now, though, you haven't theoretically paid for anything, right? Because that got terminated, that payment got terminated. Is that right?
Say that one more time.
Well, the 1266.05, she was not able to get that. That
Correct,
charge was canceled.
Correct,
Yeah,
she
so
did
we've
not
got-
finish work.
Okay, so we've got nothing paid on the contract.
I paid her $1,350 deposit. That's the money that I paid her.
Is Miss Beckett, is that part true? 1,350? I'm
I
missing
have in the
something
deposit
somewhere.
received, she paid me 350.
How much?
350.
That's a lot, Your Honor, that's a bald-faced lie. It's $1,350. And if you do the math, it works out to the penny. I'm going to break it down for you. The contract was $2,712.79.
Yeah.
I had a conversation with her about paying cash because part of this quote includes a $91.74 credit card processing fee, which I don't want to pay that if I don't have to. So if you deduct the $91.74, because I was going to pay cash, and then she said, that's great, you can pay cash, but I need to do $5 charge on your credit card just so I have it on file. I am kicking myself to this day for doing that. But I said, okay, we'll do that. I gave her my credit card information. She charged $5. Take $5 off of the total, minus a cash deposit of $1,350, and you are left with a balance owed once the work was completed of $1,266.05. And that's the exact amount she tried to take off my charge. So for Holly to say now that I only paid her $350, the math doesn't work, Your Honor. And again, another mistake I made was meeting her in a parking lot with my husband to give her the money. And I don't know why, for the life of me, Your Honor, I didn't get a receipt.
So is there, here's, I don't see.
I'm sorry, I
guess
didn't hear
Ms.
you.
Ms. Ma, on the, is something showing here that says you made a deposit? A deposit of any kind at all, whether it's 1,350 or 350. Is there somewhere on there on your contract?
No, I don't have any paperwork indicating that I paid her $1,350. But
What about
because
what about 350?
I have no receipt at all for the deposit. But again, the math works out to the penny that I paid her a $1,350 cash deposit. And if it makes any difference to you, Judge, my husband is sitting next to me. He drove me to the pizza place where we gave her the deposit, and he can vouch for the fact that it was $1,350.
And you're saying that you made that payment in cash?
It was
Your Honor,
cash.
she might be right.
She
It
might
could
be
be
right.
error on my end. She could be right. It
Okay.
might have been an honest to God error on my end. She actually might be right with that. I do know she gave me a bigger lump sum. The system just shows 350. Maybe somehow the one didn't go in. She actually might be right, Your Honor, because the math is mathing right from what Miss Mott did say for the original contract.
Okay.
Yeah,
Okay. Well,
she actually
I
might be
appreciate
right
you
on
being.
that one. I'll give her that
Okay.
one. That might be true. Yes, Your Honor.
Okay. All right. So say there's a 1,350 deposit, correct?
Correct.
If we're
Sure.
using that figure now, that would be reduced off of the original contract for the 27,1279. That would be a balance owing, at least on the original contract.
Sure.
We got all
And
this
there's
other
only
stuff
one
figured out.
contract.
I'm sorry?
There's only one contract, Your Honor.
Well, yeah, I know, but she's saying that there's two that were being worked on. I just want to make sure what I'm understanding for everybody's sake. I understand what you're saying, Miss Mott, but let's just kind of walk through what I have first. So and again, we got a lot of other little pieces of this, but the original contract, if everything had gone correctly, there would have been a balance owing of 1,362.79. So everybody can agree to that, at least if things had gone right, correct?
I didn't hear the dollar amount, Your Honor.
What 1,362.79 would have been the
No,
amount
no,
owed.
the balance would have been 1,266.05.
If she would have paid in cash. So yes, Your Honor, you're right. If you would have added on the credit card processing fee that the system charges.
Yeah, that's what I was. Oh, I
Correct.
see. Yeah, so yeah,
Correct.
yeah.
And
Yep.
the $5 deposit on the charge card. So the balance due is 1,266.05. Had work been completed, which it was not.
Yeah. Okay. So, but both of you can agree that it was cash of some sort, that part of it.
At
Yeah.
one point in time,
Okay.
yes.
Yeah.
We met up.
Okay.
Yeah.
Okay. All right. And I guess Miss Becca, just so I'm looking for it right now, show me where the interest rate is on your contract. Oh, here it is. We appreciate you coming at the end. No, it's not. Where do you get the compounded interest agreement? Where's that at?
One moment. I've switched screens. I gotta find it's underneath the first one, which is a quote, and once signed, it turns into a contract.
Okay.
So, let's see.
Your Honor, can I interject something?
It's underneath
hold-
terms of payment and
Hold on just a minute.
deposit.
Terms of payment and deposit. Okay.
Yeah. It's about, I would say, quarter of the way down. It says terms of payment deposit unless otherwise noted in the proposal. And then it says 20% yearly compounded interest, whichever is greater. And then towards the end, it says payment not to receive within 7 days will assess a 25% late fee, may turn into over into collections deposit. So,
Boy, I'm sorry. Which page is that on then? Is it on the
I have the system, so I don't have it. Let's see.
Your Honor, that paragraph under terms of payment deposits, it starts with, unless otherwise noted in this proposal, the customer agrees to pay the account in full upon completion of the work. And then it goes on to all of the late fees and all that stuff. The
Right,
work was
right.
never completed.
Right. I understand. I understand what you're arguing too. I did find it's kind of
Okay, it's on
I
page
kind of
2.
expected it was term. Yeah, it's not really
Yeah,
separated
on
out.
page 2,
Terms
kind
of
of in the
payment.
center.
That's okay. At
Yes,
least I
Your
know where it starts.
Yeah.
Yep, there it is. 20% per year compounded. Okay. Okay, so the argument, Miss Beckett, help me out with her argument that, hey, look, the work wasn't completed. Therefore, there shouldn't be a financial charge. Help me out with that. What's your position with
Wish
that?
I could have completed the work. She didn't want me to complete the work and instead stood in front of the the fence. I mean, I think
That's not
anybody-
true, Your Honor. I was pleading
Sorry,
with
Your Honor,
Holly
I'm trying
to
to speak with
remove
you,
the
but
dirt.
Hold
I
on,
guess
Miss Mott, hold on just a minute. Let me just hear from her.
Yeah.
Go ahead.
Thank you, Your Honor. So anybody in my situation, I think, would have done the same. I did go in there with I'm a pretty open, positive, optimistic person. So when I went in there, I tried to address it. She was adamant about me, and it was about 10 yards of dirt left. I still had about 5 yards to push. So I had about half of it left because the whole left side of the back end still needed a lot. I have all the pictures if you need them of how much dirt was left, how much dirt we still needed to push, how much was done. So I have all the pictures and videos if you need, if you want to prolong it to a date.
Yeah, actually, it sounds like everybody's consistent with
Okay.
what
So,
they're telling me though, but
yeah.
how do we, so if we got, let me just
Sure.
ask you this. You're telling me that there was about 80% of the work completed.
Correct.
We are looking at 80% of the work.
The work was not able to be complete with Miss Mott and
Sure.
her. Yeah.
No,
So
no, I
I
understand,
wanted
but we
to-
got eight, yeah,
Sure.
we got 80. I'm just trying to figure, so we got 80% of it is completed though.
Sure.
And then you're telling me the other 20% was the amount that you couldn't, she refused to have you come on and finish.
Correct. She just wanted me to remove 10 yards of dirt, and that wasn't a part of our contract. Like she knew that most of it would have been spreaded in the backyard, and she was okay with that when I came out to do the quote. I told her that I had a trailer that I would take away a trailer load, which would have been about the 5 yards left. And she was adamant to take it all out. She did advise to me that the guy that did the pool didn't finish either. So it does seem like Miss Mott I'm just stating by what she told me. He didn't finish either, that she had problems with him and now she's having problems with me. So I don't know if that's the thing she does. I don't know. I'm glad that she got it taken care of because she did have a dog. We were trying to, we're animal lovers ourselves. So we were trying to clear the path of dirt because it was in the middle of her yard to,
Did you
level
send
stuff.
her a billing
I most
statement?
certainly did.
After this thing all cooled
Yes,
down,
sir.
did she get an invoice? Okay.
I sent it every month. Every time she gets a compounded interest with a late fee, it goes to her every month.
Okay, so
Yep,
she's been
the
getting
system-
statements.
Correct.
Okay.
Yes, she does.
Did you get any response from the moment that you sent the statements? No?
No, sir.
Okay.
I
Ms.
mailed
Mott,
her.
help me out with that. Why didn't she's telling me from what both of you are telling me, she wasn't allowed back on to finish the work anyways. Did you ever send her a demand letter saying, listen, you come back on, you got to finish the work?
I never received anything from Holly in the mail, Your Honor. Never once. I've never received anything electronically since the contract was signed. So I'm not really sure what Holly's talking about in terms of sending me things monthly. I've never received anything from Holly ever in the mail. So I would like to see what you sent, Holly. And also, the cops were very, very succinct in telling all parties not to contact one another. So I have had no contact with Holly because the police said don't, and I was honoring their request. Even when I talked to the attorney, he said, don't do the small claims right now. Let's see how this pans out. And besides, you're not supposed to have any contact with Holly. So I haven't.
Okay.
And she was given the same instructions to, not to have any contact with me too. So, I mean, honestly, Holly, if you sent me anything, seems weird that I've never received one thing from you. And Your Honor, the job really wasn't 80% done considering the number of yards that Ace had to remove from the backyard. They did take out 18 yards. It was more than 3 dump trucks. And they did do that in less than 2 hours. And for what it's worth, Judge, I have had to pay almost $3,000 to Ace to seed, to remove the dirt, to do the hay. They did a phenomenal job. The lawn looks beautiful.
Part of the issue is the problem you have between the two of you too, though. So we got 126605. That's everybody kind of agrees that's what's owed. And Miss Becca, the statements that you were sending Miss Ma, would those have to be corrected as far as what you were sending her based upon what you're calling? Well, I'm just going to call it your mistake, saying that you only had a deposit of $350.
I'll have to recheck the math to see if the math is correct with the interest as well as the compounded. I'm sorry, the late fees as well as the compounded interest. I'd have to check the math real quick. Normally the system does it, so I would have to double check it just to make sure the math is correct with adding the $1,000 on deposit.
Do you think there's a possibility that it included the $1,350 as opposed to $350? Is that what you're telling me?
Yeah, I can do a quick math real quick.
All right.
Okay.
Sure, do that for me. Sure.
Okay,
Sure, do that for me. Yeah.
Thank you so much. Okay.
Give her a minute to do that. Miss Mott, and then we'll see what we got too.
So, Judge, are you of the opinion that I owe her more money?
I'm not doing anything yet. I'm working through things, okay? I haven't made any decision yet.
I also have pictures, Judge, if you would like to see them.
You, Miss Mott, as long while she's doing that, do you agree that you would held their equipment on your property for 2 hours?
I don't think it was 2 hours, but yeah, we did prevent them from leaving with their equipment. I do admit to that.
Yeah.
And she filed charges, and
No,
the prosecutor's done nothing as of today.
Yeah, well, it doesn't really matter whether they did anything or not, but you held their equipment for 2 hours.
But they were there to do work. So the 2 hours, if it was 2 hours.
It doesn't matter. You held their equipment there. Whether they completed the work or not, you held their equipment unlawfully, for one thing.
So it doesn't matter that for the 2 hours they should have been working on the backyard?
For me today, I'm going to make a decision on that as well for your civil part of this. There may be criminal charges though. I don't know. I don't know.
Sorry, the math is correct. I don't know how the system. The math is correct for each month.
So on the 126605, then what if you were to do all the compounded interest and everything, what's that come out to today? Just that.
Yep, it's $8,093.92.
And that's hold on, it can't be that much for the 126605.
Oh, let me see. Minusing that. No, because that got distributed back in because she didn't pay it. So the system.
So you can't really get it.
Right, the system took it in as it took it away and then it put it back in because she disputed it. So I didn't get it paid. So that amount did go back in from the 126605 plus the 2,000. So you're at pretty much 31,266.05. I don't know if you feel it's fair. I normally don't accept checks because I've had somebody. So that is with the 3.5% hard processing fee at $273.54. That's not including the $111.70 for filing as well as the fee. Hey.
Yeah, no, we haven't gotten to that yet either. So
sure.
So I'm sorry, you said so if the bottom line on what that figure is with the 1260 plus
plus the 2,000.
I'm sorry, is what?
That's with the 2,000 included, Your Honor, as well for the.
So it would be the 3,260.
Correct. It would be 3,266.05 that it was compounding off of. It looks like the system did, right?
3266.05 originally. And Miss Mott, I do have one question for you. Why would you sign a contract that's got 20% per year compounded monthly?
Because of the first sentence. The
No, I'm not talking about the first sentence. Why would you even sign something that's got that outrageous amount of interest being compounded
To be honest
monthly?
with you, Your Honor, I didn't think that we would be here today because I liked Holly. I hired Holly. I had 3 quotes done and I picked Holly because she was great. She was a woman-owned business. I liked her right away. So I never thought that we would be in a position where I would be not paying the balance for something I contracted for. But I never thought we would be in a position where I would have to hire a second company to do what I contracted with her to do. That's why, Your Honor, because I mean, I used to do contracts for a living, and you're right, I would never, ever sign a contract with those fees. But I also would never have given somebody $13.50 and not gotten a receipt. And I did that too. So I honestly, I'm hanging my hat on the fact that she didn't complete the work. And it has nothing to do with the fact she couldn't leave the yard. That happened after she said she couldn't work with me, and that was it. I knew that she was leaving me with all that dirt. I mean, the whole thing, Your Honor, was an awful, terrible experience, and I wish it hadn't happened. But in my heart, Your Honor, I know I don't owe her any more money. They didn't do $13.50 worth of work on the 6th, let alone the 7th. And she was a different person when she got out of that car on the 7th. I said, good morning. She said absolutely nothing to me. But you're right, Your Honor. I should never have signed something with that kind of late fee, but I didn't think it was a moot point. She was going to do the work. I was going to be happy. She was going to get a fair pay. All was going to be good. And here we sit.
What I guess in my mind,
Okay.
why this might what well, I guess I better not ask. Okay, so this comes into a criminal matter, I guess too. All right, Miss Becca, what anything else? All right, I'm gonna take a brief recess off the matter. I'll make a decision, come back on for both of you. Okay. All right, we can go back on the record with Trustworthy Lawn Care versus Sharon Ma. Get both on there. There you are. I did get a chance to review my notes regarding this matter. Gone through contracts. I am awarding in damages the $1,371.50 under the contract. That includes $1,266 from the original plus interest, but the interest is outrageous. I did calculate it at a 20% annual rate, giving a total of $1,371.50 for the 5 months that it has not been paid. I am awarding $2,000 for Ms. Mott withholding the release of the equipment. And actually, I'm saying that gently because it was more like people too, but for today's purposes, it's just holding equipment. Awarding court costs $111.70 for a total of $3,483.20. Judgment for plaintiff in that amount. Okay. And you're welcome. I appreciate everybody's concern. Somebody could have got really hurt. I'm glad nobody got hurt. So, and Miss, I guess Beckett, for your sake, that kept calm during that being kind of entrapped on the property too. I appreciate that. Okay. Good luck to both of you.
Wait a minute.
Okay.
Judge, can you
Yes.
give me that total again, please?
Yeah, you're going to get it on a judgment. It'll be mailed to you, but the total is $3,483.20. Okay.
So it has no bearing on the fact that she didn't complete the work. That means
Well,
nothing.
I took everything in consideration, circumstances from both sides, conduct from both sides, and that's what I'm awarding. Okay. But I didn't give her the 8,000, so she's not happy with me either. So good luck to both of you. Bye.
Versus Corey Buffkin, 25-03118 to Peat.
Anna Buckingham for the people requesting to practice under 8.120 under the supervision of Haley Hill.
Motion granted.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Buffkin, who is approaching council table now.
Mr. Buffkin was scheduled for a jury trial today on assault and battery. His witnesses here.
Yeah, Your Honor. Your Honor, today was my first chance to speak with Mr. Buffkin. I've been trying to reach him for a little while, have been unable to get through to him. At this point, I am not prepared to proceed with trial. There's been no opportunity to consult with my client regarding a defense here.
We had a final pretrial. There's been more than opportunity. There's been a pretrial. There's been a final pretrial. This has been pending to October. Today's the date and time set for trial. If he didn't want to participate in his defense, it's not your problem. You were supposed to be prepared for trial.
Your Honor, I believe without consultation with him, given the facts here, there's no competent and ethical way to prepare for trial without meeting with him.
He did that to himself.
I understand, Your Honor, but it's still my license here that I don't believe is ethically
Today's
permissible.
the date and time
to
set for trial. Why didn't you return your attorney's phone calls?
I wasn't getting any emails or phone calls.
You weren't getting emails and phone calls? Your phone number is 517-974-1411. And you weren't getting phone calls? When did you call them?
I called, I'm calling the exact dates now. I know it's early December, mid-December, and then early January, mid-January, and then again last week. Emails started getting kicked back to me as undeliverable middle of December. Voicemails I was getting phone calls I was getting a voicemail that was full and could not leave a message.
Your voicemail's full?
I guess so. I don't know.
Not your guess so.
I work so much that I don't.
Yeah, we're not recalling a witness in here. Today's the date set for trial. You have two options. You're either, and you knew you had a trial coming up. You weren't guessing whether or not I had a trial. You didn't even make any attempts to try to get in contact with your lawyer. We're calling in a jury, or you can plead to the charge. Which one do you want to do?
Call in the jury.
Thank you.
Yeah, may I have a moment to call my supervisor? Again, I do not feel that this is ethically permissible for me to proceed to trial given this situation.
You did your due diligence. Everyone knew that this was the date set for trial. And the jury is getting called in today. We're running a trial. It's not ethically permissible for you to go back and forth with me on my ruling either.
I understand. I just
you made what you wanted to say on the record clear. I made a ruling. Today is the date. The same way I would have made a ruling if the roles were reversed and they did not have their witness. When they knew today was today's date for a trial, you would have wanted me to dismiss this case. It's also a disadvantage to the state and to the victim who came here in sub-zero temperatures after this has been set for trial since November. If your client didn't want to participate in his defense, that doesn't have anything to do with the fact that you've had this discovery since October. And you've met with him more than one time because we've had more than one court date.
Your Honor, just to point out a separate thing, there is a witness not here. One of the officer witnesses is not here.
I think we received an email about that.
Yes.
That doesn't have anything to do. They say they don't need them to proceed. They're ready to proceed. The court is ready to proceed. And you were advised, we went through this beforehand. I said there will be no resets on the trials. That's why we have a final pretrial date. You had his contact information then. I'm assuming you all spoke then. If you didn't schedule a meeting then, I don't know what to tell you.
And I tried calling him the day after that final.
You should have scheduled a meeting when you had him there. You know the type of clientele you deal with. This whole, and you have a history of, you know how long it took us to get through the docket yesterday because we were waiting for the public defenders to meet with their clients. And I recognize there's situations where things are outside of your control, but it can't be that I'm here all day waiting for you to talk to your clients. That's not permissible either. It's not permissible. And so if he didn't want to participate in his defense, it doesn't mean that the trial doesn't go forward. He knew he had trial. He did not return the missed phone calls to you. He didn't say, hey, I got a trial. I should get in touch with my attorney. He made it his own decision that he's not participating in his defense. That has nothing to do with your ethical responsibility to still be prepared for trial today. Did you tell him that we're calling the jury? Thank you. Next case. You can sit that in the other room. On the record in the matter of the state of Michigan versus Corey Buffkin. This is 5-03118.
Anna Buckingham for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Buffkin, who is approaching council table now.
Okay, so Mr. Buffkin, my understanding is that you would now like to enter a plea to this original charge.
That is correct.
Okay, charges assault and battery. Do you have an advice of rights?
I do not, Your Honor.
Raise your right hand, sir. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? You can put your hand down. Okay, Mr. Buffkin, you understand that today being the date and time set for your trial, that you have the right to maintain innocence. You have that presumption, and that presumption will proceed throughout a trial. You understand that? Yes?
Yes, sir.
Okay, and at the time of trial, the prosecutor would have to prove each element of the charge of assault and battery beyond a reasonable doubt. You understand that?
Yes.
You have the right to question or cross-examine any witnesses that they call to testify against you, the right to call your own witnesses to testify on your behalf, and the right for you to take the stand, or you can maintain your silence and not have silence be used against you. Do you understand that?
Yes.
And you're willing to give up those rights today to plead guilty?
Yes.
Is anyone coercing you to do that?
No.
Any promises extended if you plead guilty? Are you currently on probation or on parole?
No.
You understand that by pleading guilty, it could result in a conviction that you may need to report to a current employer.
Yes.
It also could result in a conviction that you might need to put on a future job application, and it could have impact on where you can travel or get immigration status. You understand that?
Yes.
As to the charge of assault and battery, how do you plead?
Guilty.
Is that because you believe you're guilty?
Yes.
Factual basis?
Thank you, Your Honor. Is it true that on or about October 15th of 2025, you were present at or near 612 Leslie Street?
Yes.
Is that in the city of Lansing, Ingham County, Michigan?
Yes.
And at that time, were you present with an individual named Jennifer Feldpausch?
Yes.
And is it true that while you were present with her, there was some kind of a verbal argument between the two of you?
Yes.
And at some point during that verbal argument, you did touch her in a way that she did not want you to push or something?
Yes.
And is it true that that was against her wishes
Yes.
and not in self-defense? Thank you, Your Honor. I believe that satisfies the factual basis.
People are satisfied now.
The court is also satisfied with the factual basis. I'll accept your plea and find your plea to be freely, voluntarily, and intelligently made. So we do have the victim here, correct?
Yes, we do, Your Honor. I have his criminal history.
Any objection to immediate sentencing?
Your Honor.
I'd request it.
I want to make a statement at all.
Your Honor, I would have to check in. Is that okay? Thank you.
Cover your appearance, please.
Good morning, Your Honor. This is Public Defender Lauren Sutter on behalf of Mr. Buffkin, who's to my right.
Did your victim want to make a statement at all?
Yes, Your Honor, I have Miss Jennifer Feldpausch.
State your name for the record.
Jennifer Feldpausch.
Spell that.
JENNIFER. Feldpausch. FELD. CH.
Thank you.
Your Honor, real quick, the sheet that she just sprayed her ankle.
Absolutely.
Thank you.
What did you want to share with the court?
I just kind of wanted to give you a little insight on the impact that this put on my family and my daughter who was there that witnessed the assault. I love my cousin. I love my baby cousins. This is drew a huge divide between my family and hers, and also my intermediate family, which he continued to cause more chaos by denying the assault. And I only ever went over there to help them, take or get groceries for the family, take things for the babies that they needed, bought stuff. I was always there helping them out, which kind of made the this a little bit more, way more personal when I was always just trying to help them out. My 8-year-old was there when it happened. She didn't witness the act of it, but she heard it. She heard the commotion. She had to run out of the house with me. He had headbutted me in my face. Luckily, within 1 second, as I seen him lunging at me, I was able to pull my head back so he didn't shatter my nose. He got my 2 front teeth. Still doing going to the dentist. I still had pain in my tooth. I couldn't eat for 3 days. For probably about another 2 weeks, I had to eat off these teeth back here. I still can't bite into an apple, something hard. I still can't use my front teeth for that. I still have another appointment to go back into my dentist. And they told me if I'm still having pain, we have to look into doing a root canal. My jaw is slightly shifted where now my teeth don't sit right together no more. If I do decide to even go forward with that, I would have to re-injure my jaw to reset my teeth. And it was just over the anger and rage that came so quickly out of really nothing. Like it's just mind blowing to me the situation even happened. But I think I just hope, he showed no remorse, and that's why I'm here today. By the way, he's with my family, the way he's talked about it, the way he's lied about it. And because I was willing to let it go for his kids and his my cousin.
Let me just stop you so I can have clarity, because essentially most of the information I got came from the factual basis. So what I'm gathering from what you're saying is that your relationship with him was through your cousin?
Yes, my cousin Holly.
Your cousin Holly. I'm sorry?
Who is here today?
Your cousin Holly is in relationship with him?
Yes.
Okay.
His kid's mother.
Okay. And so you were there to help that day?
Yeah, I
or
always would
visit?
come in and help. They would take him to get groceries.
And something happened?
Yeah.
You got into something and he had butted you?
Yeah.
Okay.
Yeah. He took off for a couple hours, came back at 2 a.m. And my daughter was sleeping on the couch. And she had school in the morning. He was about where we were staying there, and he thought he was going to go sit on the couch alone with my child and turn the TV on, and she was be up for school. And there's also previous history that I know to where I don't leave him alone with my child. I simply asked him not to do that, and that is where it spiraled. He said, I can't watch TV in my own effing house, and it spiraled from there. I went out, got my cousin. I'm not gonna go through the whole situation.
I'm clear.
Okay, so yeah, it's I just feel that there needs to be some kind of consequences, and I don't feel it's simple. So I'm still ongoing with it. My daughter, I had to witness it. She was traumatized, outside crying, dealing with the cops at 2 a.m. So I just kind of wanted to. It highly impacted us and my child.
I'm sorry to cut you off. There's been no request for restitution, correct?
It's not been.
Okay.
I had the bill. I thought I turned it in. It got mixed up. I never got back over to get it. It was just the only part. It was like $80 for me to go in because I was already having
There was an initial dentist appointment for $80, but the rest of the injury requires more visits and
Yeah.
determination.
No, so something she if wanted to pursue separately. Okay. Anything else, ma'am?
No, I think that's it.
So thank you for sharing. And I can understand it being a difficult situation if you're because family's involved. Anytime family's involved, it's uncomfortable.
Yeah.
You can feel free to go back to your seat too if you would like.
Thank you.
You're welcome. Ms. Sutter.
Thank you, Your Honor. I'll be honest with you. A lot of this is brand new information. None of this is in the police report. None of this is mentioned by anyone. None of this is even described by the other person who was physically present there that day, who's also present here today. The actual cousin in question, Holly, is here, was there that night. None of that's something she has really described. Mr. Buffkin's fully willing to accept responsibility for his role in this. I think he recognizes when tensions get high and arguments occur between family members, the answer is to not try and physically de-escalate, but to just walk away completely. I don't know how credible I personally find some of what we just heard here, because it wasn't in the police report. It wasn't told to police. A lot of this is kind of brand new now, which is interesting information. It's not described by the other people who were present that night.
What portions are you? Because I think
Children being around, severity of injury. She declined medical attention.
it's in the affidavit of probable cause.
But there was she called a headbutting, and there was
But
potential
the
frontal
mention
follow-up.
of the child being there was, and that the child didn't obviously see it. That's mentioned in the affidavit of probable cause.
A child being present on the property, yes.
Yeah, on the couch when this happened.
And then we just heard her say that the child didn't witness anything, and then
She did say that the child didn't witness.
She first said she didn't, and then she later said she did witness it.
I understood her statement that not that the child witnessed the headbutting, but that the aftermath, because obviously there was a commotion,
Right.
you know, and her mom is arguing. So I believe, and I could be wrong, that's what my understanding was, because she'd already made it clear that her child didn't see it.
Sure.
So I don't think she was changing that portion. I think she's talking about the whole commotion situation. And I can assure that her child would, if her child was there, could hear the commotion, see her fighting with someone, that could be jarring. And then obviously, I'm assuming that they're not spending time with each other anymore. That could have an effect on the child too. Not discounting it, and we're not going to discount her.
No, absolutely, Your Honor.
Her position, because she was the only one that's given her position. If your client wants to speak, he can do that as well, but you're not going to discount her. And I recognize it may not have been in the police report. How many times are things not in police reports? But I do have much of this, of what she's saying about what happened. It didn't say why the argument ensued. It did state that her daughter was sleeping on the couch and that there was, that he came in and woke the daughter up. There was school in the morning. That was in that. It was how it was.
And I don't mean to discount the way she feels about the situation. I also don't mean to underplay the role Mr. Buffkin plays here. My point in saying this is I don't believe Mr. Buffkin is a violent person. I don't believe that this is a pattern for him. I don't believe it's a continuing risk of pattern for him. I think he has taken away from this situation a lot of concern about his own reactions to tense situations, verbal disagreements, especially ones involving his girlfriend, who he obviously feels quite protective of, who was also involved in this. And I don't know that punishment to the extent of lengthy probation or jail is appropriate for a person like him, because I don't think it does anything for him. I think anything that he could take away from the situation in terms of improving himself and changing the way he thinks moving forward has already been accomplished by nature of what's been going on so far. As to, again, not to discount Ms. Feldpausch's comments here, she's talking about him not taking accountability. Just a reminder, Mr. Buffkin is not allowed to communicate with her at all. He can't go and tell her he's sorry for anything. He's not allowed to be anywhere near her or talk with her. So he can't.
There was a no contact order.
Yeah.
I'm happy to hear that he complied.
Yes, Your Honor, he has stayed well away from her, so he can't do anything about taking accountability. And my strong advice to him every single time I talk to him is pretend she doesn't exist. Don't go anywhere near her. Don't think about her. Don't talk to her. Don't talk about her. So he can't do anything regarding remorse with her as long as this case is ongoing. To that, Your Honor, I believe he has a very limited or no criminal history. I don't think there's a history of concerns with violence with him. And I would ask the court today to consider fines for him, perhaps the $80 in restitution if the state has the receipt for that. But I don't believe more than that is going to achieve much for him or the community.
Client want to make a statement at all? Today, let me also remind you, today would be a good day if you wanted to apologize to do that. Do you want to make a statement?
Yes. So, what happened that night, Your Honor, was so what happened that night is I came back home from work and these two were intoxicated. I don't like being around that stuff as far as people that are alcoholics. I left. I went to wherever I went and I came back home around 2 or 3 o'clock in the morning. I grabbed the remote. I tried to turn the TV on. She came running from outside with who she was with Holly. She came running inside though. She like turned the TV off. I was like, I don't have to turn my TV off. You know what I'm saying? She like turned it off. Me being nice, I turned it off. But then when I went back to my room, I was like, you know what? I can just grab my TV, put it in my room. So when I turned the light on to get my TV, she came there arguing with me. That argument led into the room. And then we started arguing and stuff. I did end up pushing her out of the room to get away from me. I told her to leave me alone. And when I did push her, she followed herself.
So you're not, you didn't headbutt her, is what you're saying?
Right. I did put my hands on her.
But not with your head. Oh. And you didn't hit her in her mouth, is what you're saying?
No, I did not hit her in the mouth.
And
I did push her.
her child was sleeping on the sofa?
Yes, her child was sleeping.
Okay. On the sofa specifically is what I'm talking about.
Yes.
And so.
But at no point in time did I ever try to sit down with her daughter.
No, that wasn't what I think the issue is that the child was woken up when you turned the TV on or something.
Right, it was a school night.
Got it. Okay. But this is your home.
Right.
So you're feeling like this is my home. How are you going to tell me what to do in my home? And so because of those emotions, and I'm sure you probably were frustrated too because they were both drunk. You didn't want to be around it. So you already left. I'm assuming you was frustrated.
Yeah, I tried to leave.
And then came back.
And they were still awake.
And so you had some frustrations that had not been dealt with. And you came back and then was immediately met with what you felt was some aggression about and how you enjoy the use of your home. And that would make anybody within reason upset. But when you're upset, you don't have the right to put your hands on people. And especially putting your hands on a woman that's not threatening or touching you. She hasn't touched you, that's different. And your girlfriend was present?
Yes.
Okay. And so I would imagine that if your girlfriend was present, I don't know, I wasn't there, that she wouldn't allow her cousin to put her hands on you. That's what I would imagine. And you didn't say anything about the victim putting her hands on you, but that she was yelling and in your face, possibly. Is that what you felt?
Yeah. That's what. But there was like her touching me though, like with her finger like this.
She touched you with her finger?
Yeah, like my wife can tell you.
Well, for what purposes?
I don't know.
Okay.
That's just how she is. She's aggressive.
Okay.
It's always been like that.
Okay. And so did you ask her to leave your house?
I do not recall. I don't want to lie to this.
Yeah. I mean, because you have recourse too in your home. When you feel like you have unwanted guests, and it could either way this went, it sounds like it was going to cause a rift to the family. Because if you had took a different route, which would have been a more appropriate route, she's got to go. Because I don't like this interaction that we're having. And if you feel like you don't want to honor, and I think for what she said was the reason why this was so personal for her is because she feels like she's in a position where she's been helpful to you all. And this is what she said. And I'm not here to discount her experience. That's not what we're here for. You essentially didn't take into consideration that she's been there to help. And so I don't know why she and her child were there. at your home, but she felt welcome there, obviously by your significant other. And so I would agree that if there's an 8-year-old child, it is in a room sleeping, it's in your best interest not to be in the room who the 8-year-old child is for 0 reasons. I would agree. I don't care if it's your house. You have a responsibility to protect the child, but then to protect yourself from any appearance of anything that would make someone uncomfortable. There's no reason why if I was the mother, I would be uncomfortable with you being in there as well. I would too. So she says that's what caused her to go in there and say, I don't want you in there with my child.
She left me in the house by myself with her child. So I don't know anything about that. Yeah. What I know about is what she said now is that she's had some other issues. Yeah. And it could have been from that. I don't know. Or maybe something she learned after the fact. I don't know. I didn't ask her all of that. She's uncomfortable because of something that she learned, that she doesn't want you around her 8-year-old child. In general, I don't believe that women should be leaving their children or parents should be leaving their children around other people's unattended. In general, that's just a general practice. I think that will protect a lot of people in general. Yeah. It protects the children and it protects people from being falsely accused of things as well. Yeah. If they would do that, that should be a practice across the board. So I'm not discounting her experience or her concern. What I'm saying is that in your position, you had another way to handle it without putting your hands on her. She could leave if she doesn't want you in your living room because her child is there. That's reasonable. It's your living room. But you don't get to now put your hands on her because of that. Yeah, because you let some frustrations build up. It wasn't in the living room, it was in the bedroom.
I'm not saying that you put your hands on her in the living room. What I'm saying is this incident occurred because you were in your living room. Yeah. And so you don't get to put your hands on her because of that. You could have asked her to leave. I'm not saying that would have been the nicest thing to do, but you could have, because it's your house. And you can say, you got to go. I want to watch TV in my living room. And if you don't like it, you can leave. That could happen. You see what I'm saying? There's another way to address things without you putting your hands on people. He does have a limited criminal history. The only conviction I see is from over 15 years ago. However, it's a concerning conviction. I do not believe this is a situation where fines are appropriate. I believe he does need to have a term of probation. And I think he needs to do some anger management. And that's what the court's going to order. So you will do 6 months probation. While on probation, you will complete an anger management course. And I'm not going to order that you engage in testing at this time because that's not an issue before the court. I don't think that's an issue that you, even based on the statements that you said, is something that you grapple with. I think to the contrary, you didn't want them to be under the influence. So 6 months probation with anger management. You have the ability, I will give you the ability to be relieved from probation in 90 days if you complete the anger management by then. I have a form for while on probation, you're not to have any contact directly or indirectly with Miss Jennifer Feldposh. You're not to use, purchase, or possess a gun or ammunition. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. Again, I'm not going to order testing at this time. And you're employed, correct?
Yeah, I work 2 jobs.
All the more reason why you felt entitled and should to be able to sit in your living room and watch TV anytime you want. It's just a better way to get there. You understand? You'll maintain employment.
Your Honor, if I may.
Who's that? You want to add more victim impact? Is that what you're stating?
Yeah.
Or you want to address something that he said? Because I'm not going to get into that.
Right. No. Yeah, I'm already past that, but he definitely doesn't have a problem with drugs and he's gone for the 3 hours he wasn't.
Okay.
But I just want, it is a problem.
That's not an element in the case that I have
That's why
here.
he came back so hyper reactive. It wasn't.
I can't speak to that. That's not an element in this case. If that came up, ma'am, don't make me have to remove you for trying to talk over me. That's not an element in this case. So I'm not gonna order testing at this time. My concern is his anger management. He has no alcohol or substance related convictions on his criminal history. My concern, however, though, is how he's addressing his anger. And that's based on, this is not the first time he's been charged with an assault and battery. There's also some other concerning things on his criminal history that he's very much aware of. There's a $75 crime victim rights fee that will be assessed plus a $50 state minimum cost that will be assessed. Probation is $30 per month. So if you do 6 months of probation, that'll be $180. But if you do half of that, it'll be $90 plus the $125. The max fines and costs is $305, but you can make monthly payments on that. Do you have any questions at this time? That's the total, but you'll be making monthly payments. If you're discharged early, you will not pay that full amount, okay? Because it's $30 per month to be on probation for oversight, okay? Do you have any other questions? You go and check in with our probation department before you leave here, and then you'll be all set. Any additional matters for the record?
Not from the people. Nothing further.
Thank you.
The court draw there, the says,
May be seated. Court does call the case of the people of the state of Michigan versus Michael Joseph Peat. Counsel, state your appearances.
Alex Chavalowski for the people. Thomas Heed for the defendant.
Thank you. Your name, sir?
Michael Joseph Peat.
Thank you. All right. Taking time set for trial. Are we ready to proceed?
Yes. Yes.
All right. You may proceed.
There's people are willing to waive opening if counsel wants to, or I can.
We'll waive. All right. Okay. So you have no objection to their waiver?
No.
And you're also waiving? Okay. All right. May I call you first, Liz?
Right. We call Erica.
Ma'am, please come forward and be sworn.
See, raise your right hand. Do you solemnly swear to the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? See. Record, please.
Erica Logan. Erica is Erika, last name Hogan Logan.
May I inquire?
Thank you. Erica, where do you live?
At 480 West Clarkville.
Okay. And is now back on June 14th, 2025. Do you remember that day?
Yes.
And on that day, did you live at 4800 Clark Road, apartment 313?
Yeah.
Or excuse me, 30. Yeah, 313.
Yes, apartment 313.
Okay. Thank you. Now, at about 9 p.m., did something happen that caused the police to get called?
Yes.
Okay. Take us through what you were doing prior to the police getting called.
Prior to the police conversation, I was moving in.
Okay. And when you say you're moving in, was this a new apartment to you?
Yes.
Okay. So what were you all doing? What were you all moving in?
Those boxes.
Okay. And about how long was that taking you that day? Now, was your apartment is that in Ann Arbor, Michigan?
Yes, it's, yeah.
And is that in Washtenaw County, Michigan?
Yes.
All right.
Well, it's not in Ann Arbor.
Oh, I'm sorry.
I want to make sure.
Pittsfield Township, correct?
Yeah, it's more than Ann Arbor.
We don't have much of Park Road, but I'm sure we probably are. But I recognize that it's in Washtenaw County in 14A districts.
Thank you. Now, so you'd been moving in, and around 9 p.m. or so, did something happen to interrupt your moving in?
Yes.
What happened?
There was an altercation.
What do you mean an altercation?
I was walking down the third floor hallway to my unit to take things in. I was approached by someone, and basically what happened was I guess he's upset about the noise that was going on with us moving in. And he made some pretty obscene statements to me, my mother, my daughter, and one of her friends.
Is that person in the courtroom today?
Yes.
Can you point him out and describe what he's wearing? Can you describe what he's wearing, please?
A tan 3/4 zip sweater.
Okay. And do you know who that person is? Do you know their name?
I just want to.
Okay. Ask the record to reflect identification of the defendant.
Objection, record, so with one.
Thank you. Now, you said that there was some words that were stated by him. What did he say to you?
The statement that he made was, you guys are playing around and ass grabbing in the hall.
Okay. And when this happened, whereabouts in the hallway were you?
I was about face to my door. So between the elevator and my apartment unit, I was about halfway there. Yeah.
And now he lives in apartment 306?
Correct.
And is that also between the elevator and your apartment?
That apartment is actually right, almost kind of like directly across from the elevator.
Okay. But would you have had to go past 306 to get to your apartment?
Yes, like I would have, as I was stepping off the elevator, you're right there.
Okay. When he approached you and said that you guys were ass grabbing in the hallway, where in line was your mother and your daughter and her boyfriend?
As we were walking down the hallway, I was in the front. I want to say my mother was behind me, then it was my daughter and her friend.
Okay. Now, when you are going down the hallway, who did he confront first?
It was kind of like he generalized the statement to all of us. And it kind of didn't get directed towards me until we got closer to the door.
Okay. Did he get in front of you as you were walking down the hallway, or what happened?
He ended up kind of like on the side of me as we were going down the hallway.
Do you know if he followed everyone and caught up to you, who was first in line?
That's what happened.
Okay. Now, when he got up, even with you, did he say anything else?
He was pretty much just making statements about how loud we were being. We should have picked a better time to move in, and it just that kind of was the gist of what he was saying.
Okay. Why did you move in at that time?
That was the time I was able to.
Okay. Was that based on your schedule?
Right.
And your help's schedule?
Exactly.
Also, your work schedule?
Yes.
All right. Now, were these relatively new apartments at that time?
This is a new apartment complex. Yes.
Okay. And the apartment complex had been there about a month in total, give or take?
Yes.
All right. Now, did you approach your apartment door?
Yes, I did.
Okay, what happens at that point?
As we approached the apartment door, I kind of, just thought he was going to go away. So when we went into the unit, he stopped the door with his foot and proceeded to shove past me, push past me to gain entry into the apartment at that point.
Who opened the apartment door initially? And did you go into the apartment first, or did you let other people go in?
I went in, but the way that the doors are set up, they're slow closing doors. So you don't close the door behind you, it kind of closes on its own. So as I walked in, everybody else kind of walked in behind me. And before the door closed, that's when he, kind of like stopped the door. And when he stopped the door with his foot, that's when I turned around and I was at the door. And he pushed past me to try to come in.
Okay. Now, when you say he stopped the door with his foot, did you see where his foot was?
Yeah, it was. So when the door is closing, it's kind of like the silver, threshold of the door area. He put his foot right there to stop the door from closing.
And was it towards the side of the door where the handle is, or the side of the door where the hinges are?
Where the handle is.
All right. And then you said that. So where were you at that point when he put his foot to stop the door being closed?
I was right in front of the door.
Okay. When you say in front of the door, on the outside of your apartment or the inside of your apartment? And when you say, now describe what you mean by he pushed past you.
So when he put his foot in the door, I still tried to close the door, and he had his forearm out like this, and he did like this and kind of like stepped into the.
Okay. Now you just made a motion with your forearm.
Yeah.
You have to kind of describe for that because we're recording things and so can you describe the arm motion that you were just making or the position you put your arm in?
Yeah. So he extended his forearm out towards me, and when it kind of pushed into my chest, that's when he stepped into the apartment.
Okay. Now, so he had put his foot in a place that would prevent the door from closing completely.
Correct.
Did you open the door back up, or did he push the door open?
No, that's the thing. Before the door could completely close, he stopped it with his foot.
Okay.
And when he stepped into the apartment, that's when he pushed me with his forearm.
Okay. And did you see what was pushing the door, or was anything pushing the door? Better question.
No, I mean, his foot had the door open, and
Okay.
once he stopped the door with his foot, he could essentially put his arm in the door.
Okay. Inside your apartment?
Correct.
All right. Now, using could you see if he held the door open with his arm? Did he use his arm on the door at all?
I don't know where his right arm was.
Okay.
I just could see the left arm that he used and the foot that he used to stop the door.
I see. Now, did his left arm make it inside of the threshold of your apartment?
Yes.
How much are using using your hands, and then we'll kind of approximate that. How much was your door still open when he stopped it?
When he caught it with his foot, if I had to gauge about how much the door was still open when he caught it with his foot, it was probably about this much space before the door closed.
Okay. And that's, are you any good with the measurement?
12 to 15 inches, I said.
Okay. Thank you, Judge. And did the door open more in this incident?
It prevented the door from closing.
Sure.
So I don't want to make the assumption, but the only thing I can assume is that his right hand had to have been on the door.
Fair enough. And we don't want you to guess. Okay. But when he used his left hand, did he have to reach around the door to get to you?
No, it's kind of almost when he put his arm out and pushed me through the door, the door opened more at that point.
Okay.
So
and you
just stay at that same angle the whole time.
And correct me if I'm wrong, but you're gesturing in a way where his left arm is pushing on you.
Correct.
Okay. And that's about shoulder height or so on you?
Yes.
Okay. And at that point, Let me back up. Did you invite him in your apartment?
I did not.
Did you say, hey, come on in, we'll talk about this?
No.
Before he stopped the door closing, had he said anything else to you about the noise?
He was just still talking, repeating the same thing, like, you guys are playing around in the hallway, the ass grabbing, and, you should have picked a better time to move in and all these kind of statements. And it was more so me walking away, going into the unit, like trying to ignore the conversation.
Once the door is held open, does the defendant say anything to you?
The same thing. He was just saying the same thing, and it kind of turned into at that point of, can you, get away from my door?
Okay. Now, did you tell him that?
Yes.
All right. Once he holds the door open, what did you tell him?
Can you get away from my door?
Okay. Sorry.
Can you just leave?
Did he respond to that?
He continued to talk and stand there.
Did you do anything else?
I did not.
Did you ever try to push the door closed?
My daughter.
And did you?
How old is your daughter?
17.
17.
Yes.
Thank you.
What did it take to get the door closed? Or actually, maybe back up. Were you eventually able to close the door?
Yeah, my daughter actually closed it.
Okay. And other than saying, I think you said that please back up or something. Did you tell the defendant anything else?
I told him that I was on the call police.
Did he say anything to you at that point?
Just still repeating the same thing. I guess he was upset about the noise.
How far into your apartment did he get when he tried to push his way in?
About like the whole left side of his body.
Okay. But was the right side of his body still, if we use sort of the threshold of your door as an imaginary force field, half of his body's inside, half of his body's outside?
Correct. Yeah, because he came in at an angle because of how the door still kind of was at that point. And when he made the motion to push past me, he kind of stepped with his left side. So
It's not like the door ever swung all the way open.
no.
And you didn't pull the door open as he was standing there preventing it from closing.
Can you repeat that?
You didn't open the door as he was standing there preventing it from closing.
No, I didn't.
All right. Did you want to continue the conversation with him?
No.
Why is that?
Because I don't know him and I didn't know what he was going to try to do. And at that point, like I said, my daughter was home, her friend was there and my mom. So I was trying to avoid the confrontation.
And now, thank you. I don't have any other questions. All right.
Before you begin, Cross, what time was this happening, ma'am? You said 9 p.m. was when you're moving in, but when this happened.
I can't remember the exact time I called the police department. But I called them right after the incident took place.
Okay. All right. And just also for clarification, you said your mother, your daughter, and who else was with you?
My daughter's friend.
Male or female?
Male.
Cross-examination.
Thank you, Your Honor. Good morning, Ms. Hogan. Where do you work?
At Washington Community College.
Okay. How long have you been there?
A little over a year.
At any point, were you trying to get hired by the community corrections for the jail here?
Yes.
What is the relevance?
They had quite a extended talk while she was talking to the police about her plans to become a police officer. And she stated that they had encouraged her where she already was to become a police officer. And one of the police officers responding said, "We're hiring." And it goes to show bias of both the witness.
Understood. You can go ahead with the questioning. I'll overrule the objection.
So did you at any time indicate that you had applied to be a corrections officer?
Yes, I did.
Okay. So I want to go back. The incident you're talking about here happened on June 14th, correct?
Yes.
You live in one unit and your mother lives in another unit on the same floor. Is that correct?
Yes.
When did your mother move in?
Objection, relevance.
Overrule. I'll allow.
A few weeks to a month before.
And do you recall who was helping you move in that time?
Moving for.
To your mother's. Who was helping?
It was me, my mother, my daughter, and her friend.
Okay. And did you encounter the defendant that evening around 11 p.m. when he came out to the parking lot to discuss you're still moving in?
Yes.
Okay.
So just so that I'm clear, we're talking not about the June 14th, but prior to when your mom was moving in?
Correct.
Okay, go ahead.
And at the time, did you claim that you needed to finish in order to return that truck the night of your mother moving in?
Did I make that claim to?
To Mr. Heed, the defendant, not to
Yes.
confuse you. Okay. I'll refer to my brother as the defendant just to make sure that we don't have any confusion here. Did you know your move-in date when you were moving your mother in?
No, I didn't.
Okay. Between the time you moved your mother in and the time you moved in, did you discuss the time of day that you would be moving in? Do you recall the events of June 14th relatively clearly?
Yes.
Okay. You had stated that the defendant said ass grabbing. Are you sure he didn't say grab assing?
From what I recall, he said ass grab.
And on the 14th, did you remove the goods in that truck from another location? In other words, you were moving from someplace to 4840. Did you both load and unload that truck on the same day?
Yes.
Okay. What time did you start?
I don't recall the precise time I started to move the truck.
Okay. And when you had talked to the police that evening, you had stated that that was your last load.
Correct.
Is that correct? So do you recall who was carrying goods from the truck up to your apartment in the last load?
The very last load, I don't know who all had something in their hands. So I don't know.
Okay. And you had testified, I believe, that you never opened your door fully, correct?
Correct.
How did you and the other people with you get the goods that you were carrying into your apartment if you never opened the door fully?
We came through the door. We didn't have to push the door all the way open to its maximum ability for everybody to enter the unit.
So what was being carried?
Again, I don't recall, but all of the big things were already in the apartment at that time. We were bringing in the last of the stuff off the truck.
How do you open the door to that apartment? Is it a key or a card?
It's a file.
Okay. And Who had the fob? And the door was locked when you got there.
When I got there, I don't remember if I had to swipe the fob to get in or if it was already open due to the fact that we were coming back and forth with the truck. I don't recall on that particular trip if we had locked the door before we went back downstairs.
And you had mentioned that you have a soft closed door. At the end of the soft close, does it soft close right to the end, or the last several inches does it slam?
It slams at the end.
Wouldn't that hurt somebody's foot if that door slammed right at the end, if they stuck it in? When you were moving in on 614, you were aware that the building that you were in wanted everybody to be relatively quiet. And in fact, you signed a form that said quiet enjoyment, didn't you?
I didn't sign that.
I'm going to object. There was a cop-out question.
Fair enough. I can separate the question out.
Go ahead.
So did you, prior to moving in, sign a form concerning quiet enjoyment of your unit?
Yes, I did.
And so when you moved in, you were aware that that community observed quiet enjoyment.
I was aware that they observed quiet enjoyment as a resident of the property that did not pertain to me.
Does it say anywhere on that form that it doesn't pertain to moving in?
It is not.
So where did you learn that it doesn't pertain to moving in?
You can't move into a property quietly. There's going to be noise when you do that.
What noise in particular did the defendant complain about?
They heard us in the hallway.
Were you laughing and carrying on?
We were talking.
Were you laughing and carrying on in the hallway?
We were talking.
Did you say to the police, or your mother say to the police in your presence, that you guys
To the hearsay.
Fair enough.
Go ahead.
Strike that. I'm going to ask this a different way. Isn't it true that you told the police nobody could tell you, nobody could dictate when you move in?
Yes, I did.
And did you also tell the police that no one can tell you how much noise to make when you're moving in?
I said no one can gauge how loud it's going to be when you move in. I didn't. I said yes.
Nothing further.
Any redirect?
The conversation about trying to get hired by community corrections. Did that happen? When in that evening did that happen?
That happened after the fact, once I kind of called and explained to them what's going on.
So the police had talked to you
Yes,
and they went inside, right?
they went inside to talk to him.
Okay. And they came out and at least had told you that they had talked to him.
Yes.
All right. And then it was sort of in casual conversation afterwards that came up. Okay. Nothing further.
Ma'am, what were if you recall, what were the last things you were carrying into the apartment?
I don't recall.
But it wasn't like you had said, correct me if I'm wrong, that the large things were already in.
Correct.
So one could assume you weren't like carrying mattresses or couches or anything at that
No.
range. Okay. And you're not sure as to what time this is. Did you receive a complaint or communication from the apartment complex regarding moving in?
No, I didn't.
Any noise or anything? The ass grabbing or grabbing ass, whichever, was that comment directed at you? Well, let me ask it a different way. Did you have an impression as to who that was directed at?
The impression that I had was that he treated me to all.
What did that mean to you? That terminology, that phrase.
That you guys are playing around in the hallway and almost kind of like we were children playing in the hallway, just being loud.
Okay. Any questions based on the court's questions? From either side.
I do have one.
Actually, a couple. At the time that this incident happened, did you think you were being too loud?
No, I don't.
Okay. How loud, if you recall, about how loud were you talking?
It was just an average conversation.
Any louder than we've all been talking today?
No, I don't. No.
Thank you.
And break it down. When you were moving the last items in, because you're moving in, I'm presuming, and I may be wrong, all the four of you weren't all coming in at the same time, were you?
No, we weren't. We all got off the elevator and we all were heading to the apartment.
Was that true for the whole move?
No.
Okay, so at certain points, and again, correct me if I'm wrong, at certain points, there might be others, two or one of you that would go down, come up, and then
Correct. We're going back
and forth. So not all four of you were together always.
Right.
Okay. Before this incident you described, though, you're indicating to the court that all four of you were coming in at that point?
Yes, it was the last trip from the truck at that point. We were wrapping up.
Okay, gotcha. This prior occasion that you and the defendant came into contact, I guess when your mother was moving in.
Mm-hmm.
Was there anything eventful about that encounter?
Yes, it was actually. He approached the truck. We did, obviously we did not know who he was. He was like, you guys are being very loud. Why would you decide to move in at this time? And at that time I expressed to him, you can't control when people move in. You should be aware that you're moving into a building that's brand new, so people are going to move in, and there's no time restriction on that.
Okay. And this was 2 or 3 weeks prior to the 14th. What time was it that movement was occurring?
That was later in the day. This was probably, it was dark outside. I can't remember an exact time, but it was later in the day. Like late at night.
Okay. That day, that previous day, was there only one encounter between you and Mr. Heat?
What do you mean the day my mother was moving?
The day your mother was moving.
There was one encounter. Yes.
Okay. And it was as you described that he came out to your truck.
Right.
Okay.
He also made a statement about us letting the building door slam. He said, you guys are right under my unit with the door. But if you're moving things in, you can't really control the door. You're not holding the door and holding on to things at the same time.
Well, okay. So then on the 14th, was the same thing happening where the door was slamming?
I'm not going to say that it didn't slam at all because, again, we did have a big thing that truck. It required us as we were going in to use both of our hands.
So if the door were to kind of close hard behind us, we didn't have control of that every time.
Okay. But at least on the first occasion, there's complaint about the noise and also the door slamming and his proximity, or at least what he relayed to you, his proximity to where the door is.
Yes, and then he made the statement about us needing to pick a better time of day to move in, as if he had control.
Well, but let me just ask this. You indicated that on the 14th, you moved in at 9 p.m.
It was a little bit before that,
Okay, but it was around 9.
but we were there around that time.
Well, you, in questioning from the prosecutor, you said you were moving in about 9 p.m.
We didn't start at that time, that's what I'm saying. We're already there. So we had been moving in for a minute at that time.
Okay, fair enough. On the weeks prior, you had indicated that it was a later time that you moved in.
Yeah,
So it
we got
was-
later start.
So it was sometime after 9?
No, we were there after 9 o'clock. We got there a bit later that particular day, but which kind of had us stay there longer. So the 14th, when I moved in, I pulled up with the truck maybe 4 or 5 o'clock in the afternoon, something like that, when we initially started. But on the weeks prior, when me and my mother was moving in her stuff with my daughter and her friend, that was a bit later in the day when we initially arrived. So maybe like 7-ish or something. So we were still there.
Okay, so maybe I have a misimpression and I just want to clear it up. Prosecutor indicated, or your response to the prosecutor in regard to a question was that this was occurring at 9.
The incident with the defendant.
Yeah.
Yes.
Okay. So you had been moving in since on the 14th, I'm talking about, since about 5 o'clock?
Yeah, 5 or 6, something like that.
Okay, so this is 4 hours thereabouts that you're moving things.
3-4 hours in, yes.
Okay. You arrive when you're moving your mother in.
Mhm.
You arrive a little bit later. Does it take that same amount of time?
I can't recall how long it took us that day exactly, but I do know it ran later into the night than when I moved in on the 14th.
Gotcha. Okay, fair enough. So during the previous incident, at what time did the defendant come down to the truck?
Again, I don't recall the exact time. I just know that it was later in the day. It was already like nighttime. It was dark outside and kind of later in the evening.
When he came down to the truck.
Correct.
So maybe we'll do it this way. When he came down to the truck on that occasion,
Mhm.
were you at the end of the move or?
I can't recall how much stuff was left on the truck. I just know we were still in the process of getting things off.
Let me ask it this way. If you had to, I don't want you necessarily guessing, but if you can approximate, were you halfway through the move? Were you 3/4 of the way? And I'm talking about the previous occasion.
With my mom.
Yeah.
And her things. Say maybe about a quarter of the way. I had to try to
So
regulate.
you were about a quarter of the way done when he came down to the truck.
Correct.
All right.
Any questions based upon the court's questions?
No, Your Honor.
I have a couple that might help. I hope help. When you moved your mom in and on the 14th, did you think you were making any unreasonable noise moving in? Was it sort of the standard noise from moving in that you would expect into an apartment complex?
Yes.
All right. Now, were you trying to make a bunch of noise when you moved in?
No.
Were you trying to be aware of the other residents? Thank you.
All right. You may step down. Thank you. Call your next witness.
People are asking. Oh, I'm sorry. No, I do want Officer Rakowski.
All right. Sir, please come forward and be sworn.
Will you take a seat, raise your right hand. You solemnly swear and affirm the testimony filed here will be true, the whole truth, and nothing but the truth, so yeah.
Thank you.
Go down and see. State your first and last name for the record, please.
Colton Rakowski, COLTON,
All right, you may inquire.
Thank you. You work for Pittsfield Township Police Department?
Yes, sir.
And were you working on June 14th, 2025?
Yes, sir.
At about 9:08 p.m., did you get dispatched out to 4800 Clark Road?
The call was originally dispatched to Officer Dana and Officer Tripp. I jumped the call shortly after that bit system.
Okay. Was that about the time that the call came out, though?
Yes, sir.
All right. And when you arrived, had Ms. Hogan, to your knowledge, completed her move by that point?
To my knowledge, at that time, I'm not sure.
Okay. Thank you. Nothing further.
No, Your Honor.
All right. Thank you.
Now that people are interested.
Witnesses for the defense.
The defense calls the defendant, Michael Heed.
All right. Sir, please come forward and be sworn. Not actually, the other face. Just come on up. Like. Sir, before you have a seat, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Have a seat. Upon having a seat, please state and spell your name for the record.
It's Michael Joseph.
You may inquire. That's fine. We've got the spell.
Okay. Mr. Heed, how old are you?
So,
Now, before we get too far along on this, I want to ask you, did anything occur a couple days before June 14th that was of note in your life?
Yes, I had pretty major facial surgery.
Okay. And when you say pretty major facial surgery, what exactly did they do?
They trim my eyelids and raise my eyebrows. And there's a lot of stuff in the face.
So who did that surgery?
Dr. Simmons at Kellogg Eye.
Did they provide you with any information about what you could and could not do after the surgery?
Oh,
Just make it quick. No, I think this is going exactly, Your Honor. This shows that he could not have done some of the things that he was accused of that night.
That's the reason that you're offering this testimony.
Yes.
Judge, being told what you can and can't do has no bearing on what you do and do not do.
And certainly you're entitled to make that argument. Objections overruled, you may.
So, stated shortly, what did they tell you?
Yeah, with more than 5 pounds and not over Sleep on your back so you don't abrade the stitches. Your clothes unused so they help with the swelling.
And so where were you sleeping after the surgery?
On my couch because it has rolled arms like an extra pillow.
And as part of your preparation for this surgery, did anything in your unit provide you concern?
There's a pre-operation session and got a less detailed list of restrictions after the surgery. Among them, 5 pound limit on weight. So I was concerned that the apartment door, since it's heavily damped, would exert more than 5 pound pressure. So I measured it. It was indeed, in excess of 20 pounds.
Okay. And so I want to take you now to the first time you encountered Erica Hogan. Do you recall approximately what time you went out to the parking lot?
I said after 10. She said on the stand 11. I'm willing to accept that. It was dark.
Fully dark. Okay. And what did you say at that time?
I said, it's kind of late. It's kind of noisy.
After talking with them, did you think that they were going to stop immediately or they were going to continue?
I got the feeling that they were going to continue till the job was done.
Did they in fact continue until the job was done that evening? Okay. So I want to turn your attention now to the night of the 14th. Where were you in your apartment when you made the decision to talk to the Hogans?
So I'm between the couch and a recliner. When I get tired of laying in one position, I would switch to the other place and try it after a while.
And what caused you to get up?
Well, it was 9 o'clock, so that, it was starting to, the sky was starting to darken a little bit. My body was telling me that it was in a space where it could get some serious sleep rather than just cat napping. So I was trying to get some serious sleep.
And did you hear anything that made you get up?
I heard the Hogans and company, both downstairs and upstairs. They're both in very close proximity to my apartment.
How far is the elevator from your apartment?
About 15 feet.
And did they arrive up at the elevator before you got up or after you got up?
Oh.
And when you left your unit, what did you do? Did you, well, strike that. Did you have shoes on? Did you put shoes on before you left your unit? When you left your unit, did you see the Hogans?
I did not. I could hear them. Not see them.
When did you first see anybody in the Hogan grand party?
Well, there's a curve in the hallway at the elevator, so once I got past the elevator, I could see them.
As you approached unit 313, did you catch up with any member of the Hogan moving party before you got to 313? When you got to apartment 313, was the door open? How close were you to the last person going into the apartment?
Maybe 5 seconds behind.
How far is it from that elevator to the Hogan's door, to the door of 313?
50, 60 feet.
When you got to the door of 313, it was open. Who did you see inside?
Yes. You said it was open?
Yes.
Okay.
Who did you see inside the apartment?
So Erica, she was holding the door. Angela was in the laundry room, which is off to the left of the entry. And
Did you see anybody else?
the two young people were further in the apartment, kitchen area.
Could you see them?
I don't believe so right away.
And what was your purpose in going to apartment 313?
To tell them I was badly in need of sleep and that they were making more noise than I felt was necessary. And the management wants to emphasize people's right to quiet enjoyment and like a courtesy visit of complaining to the management about what you're doing.
What happened when you started talking?
Everybody else started yelling.
Did you use the words ass grabbing when you started talking to them?
I believe it was grab ass.
What does grab assing mean?
It's from the Army. My drill sergeant alive. It means horseplay, moving around. Anything that's not directly pertaining to your assigned task.
And did they have any reaction when you use that word?
Maybe not. They definitely got agitated and misunderstanding that might have been part of it.
How long did the whole encounter with Erica Hogan last?
I would guess 15 seconds.
Did you ever intentionally enter her unit?
I did not.
Did you ever touch her?
I did not.
Did you ever touch her door?
I did not.
Did you put your foot in the door to stop it from closing?
I did not.
Would you put your bare foot in one of those doors to stop it? Why not?
It may survive the incident, may not.
Okay.
Too close to call.
Your Honor, I would like to show the witness and the court the door that is to the witness's apartment to show the closing mechanism.
There it is.
There we go. All right. So let me back this up to start. So.
Defendant's K is being admitted.
This is a demonstrative video just so that I can answer additional questions. We can't admit Exhibit K also. So if you turn to your book, Exhibit K.
Any objection to the admission of Exhibit K? All right, Exhibit K, the video is admitted as well as the picture of the door. Go ahead, counsel.
So you had earlier indicated that you had concern about your own door and its weight.
You need to, correct? You need to. I don't know what's, okay, there we go. Go ahead.
Yes, thank you. Just to make sure we don't inadvertently project anything else. You had indicated that you had concerns about the weight of your own door. Given your concerns, were you in a mood on June 14th to push past anybody?
No, in fact, it was the impression given to me by the surgeon that my face could, in a sense, fall apart if I overexerted myself.
Okay. You recall approximately how many sentences you tried to say to Erica Hogan?
Three. Too much noise management concern and making a formal complaint.
Okay. And when you say management concern, has management told you as part of the residents at 4840 that everybody needs to be quiet?
Yeah, there were just a couple at that point. That was like 3 weeks after I moved in. Through emails that said, reminding you that there's, quiet enjoyment policy.
When you approached Erica Hogan on the night of June 14th, what was your expectation of what was going to occur?
Well, I was hoping just to deliver the message and go back and try to be a little more quiet.
And since you have been at 4840, have other people moved in?
Yes.
Has anybody moved in later than the Hogans moved into Angela Hogan's apartment?
Angela was definitely.
Did anybody else move in as late as Erica Hogan? Did you complain to anybody else about the noise they were making moving in? In your own assessment, were the Hogans louder than other people when they were moving in?
Yes.
Nothing further.
Cross-examination.
Thank you. You didn't have any trouble opening your door on the 14th around 9 p.m.?
Um,
Well, let me ask. Okay. And you opened it to go talk to Angela?
yes.
Or excuse me, Erica. You also opened it when the officers knocked on your door?
On my crack, yes.
Well, you opened it enough so that your entire body was between the door frame and the door?
Oh, yeah.
Okay. And you didn't when the officers asked you for identification, you went back into your apartment to get it. You didn't ask them to hold the door for you because of your eye surgery, did you?
I did not.
Okay. You told the officer that you'd put your foot inside of Erica's door?
I did.
You didn't say that?
No.
Okay. You told the officer that you didn't get into her apartment more than a foot? Is that correct?
The statement I remember is I may have put a foot in the apartment. And at that point, immediately after the incident, I wasn't sure.
So you didn't say that you didn't get into her apartment more than a foot?
Unqualified, I would not say that, no. Because I had no intention of her apartment.
Did you tell the officer or not that you did not get into her apartment more than a foot?
Again, my recollection is that I told him that I may have.
Your exact words were that you got your foot, you stepped inside the apartment, but it was inadvertent. Do you recall making that statement?
That's very urgent.
Do you believe the same rules apply to you as they do to Erica Hogan? So she should be able to enjoy the quiet enjoyment of her apartment?
Yes.
And not have people hold her door open? You said you saw people in the...
So that we're clear, because this apartment complex has the legal definition of what quiet enjoyment really means misconstrued.
I think we could probably stipulate that within the lease, Judge, with court's information. they redefine quiet
I know,
enjoyment.
I understand that, Mr. Tibulowski.
Okay.
I just want to make sure that the record's clear.
Oh, thank you.
That we're not talking about legal quiet enjoyment, that we're talking about what the apartment complex has called quiet enjoyment.
Yes, we will stipulate to the fact that it's not the legal definition, Your Honor.
Thank you.
I actually got out blacks last night to look at, to make sure I was thinking correctly. Thank you, Judge. You told so we saw the video of the door closed. How is it that Erica's door didn't close behind her like in the video? Well, let me back up and I'll ask a different question. You said that you saw some people inside the apartment.
Yeah.
Okay. And you had followed Erica over to her apartment
Mhm.
and as a yes. And
She was not the last. Her daughter and her daughter's boyfriend were the last two in line, so they were, I guess, essentially the ones that was following.
but you passed them and actually caught up to Erica.
Never passed anyone.
Okay.
We were all in the compartment.
All right. You told the officers that the person you were talking to, was that Erica?
Yes.
Okay. You told them that she turned her back to you. Is that correct? Does that signify that she doesn't want to talk to you at that point?
I think it was, my impression was it was to get out of the way of the door so they could close it.
Okay.
At least far.
Okay. Now, and you told them that when she turned her back to you, you still wanted to tell them that they were being too loud.
Yeah, I wanted to finish my statement, and the noise created by the four people in the apartment yelling at the same time made it difficult for her to hear.
So Erica was past her door, letting it close by this point?
She was still in front of him. Yeah, she turned and was, going to get out from in front of it.
Earlier on your direct examination, when you were asked if you had touched Erica's door, you shrugged your shoulders. Do you recall doing that? Okay. Do you recall for sure whether or not you touched her door? We don't want you to guess.
Her door may have touched me as far as sticking my foot in the door. That did not.
Okay. Thank you. I don't have any further questions.
Sir, just so that I'm clear, your intent on going down was to tell them that they were being too loud.
Right, that I stood a realistic chance of actually getting some sleep for the first time in a couple of days.
And the prior occasion, what was your intent on approaching them at the truck?
Well, that was much later. That was, she said 11. I just said after 10. And that's the generally accepted definition of quiet time. My understanding is between 10 at night and 8 in the morning. So,
okay, well, so my question was, when you went down to the truck on the prior occasion, what was your intent? Just to tell them that it was too
yeah,
loud?
tell them it's after 10.
Okay. It's been indicated that you said that in questioning from the officers that you may have inadvertently stepped into the apartment.
Yeah, that sounds accurate.
Okay. When you left your apartment and were going down the hallway, did you have any intention on going into her apartment?
No.
You get to the door, and at some point while you're at the door, you don't know whether or not you crossed the threshold.
No,
is that correct?
I was trying to stay close to her ear because there was a lot of ambient noise that I had to talk around.
Okay. So she's at the doorway, right? At the time that you get to the doorway.
Yes.
How far from, if you recall, from the threshold was she while you're at the door?
She was like at the handle end of the door with the door like fully open, and she was holding on to the door.
So when you approached the door was fully open.
Yes.
And so you're standing there talking. All right. When you say she's at the handle end of the door, was her body to what would become the outside of the door or the inside of the door? If you know what I mean by that.
Kind of both. She was at the end, with her front like bent around on the side and her, back maybe behind the door.
Okay, so, and you've, by your description and by what you were doing, what I took from that is her body is actually behind that door.
Part of it.
Part of her body is behind the door. Is the door closing at that point?
No.
Or she's just behind it?
Yeah.
Part of her is behind the door. And is her face facing out?
Yes.
Okay. And at that point, you're talking to.
Yes.
To your understanding, at that point that you're saying anything, is she trying to close the door?
No, I didn't get the impression anyone was trying to do anything other than make a lot of ways and scare me away.
Okay, when you say that, was somebody saying something to you?
Well, they were all yelling, get out, go away, but whatever.
Okay. At some point you leave and the door closed and you walk back to your apartment. Is that correct?
That's correct.
So would it be correct in saying that once you arrived at the door, it was anything but quiet necessarily?
Well, as soon as I opened my mouth to say too much noise, and everyone lit up immediately, almost immediately.
Got it. Okay. All right. Any questions based on the court question?
I don't have nothing further, Your Honor.
I do have one other question. The previous occasion, did you report that to management?
I don't believe I did.
Okay. This occasion, did you report it to management?
I did not, because by the time the next day rolled around and management was in a position to receive the message, things kind of snowballed. So we were on a different path at that point.
Gotcha. Sir, if you thought there was too much noise, is there a reason why you didn't call the police?
Well, two reasons. I moved to this apartment complex from Evergreen, which is also in Pittsfield Township, and I called them with noise complaints a couple of times. They told me not our problem, that should be taken up with management, and also the management sent out a group email that said, don't call the police about noise complaints, take it to management.
Got it. All right, fair enough. Any questions?
Nothing. No.
All right. You may step down. Thank you, sir. Any additional witnesses for the defense?
Your Honor, the defense rests.
All right. Any rebuttal witnesses for the people?
Just recall Officer Rakowski very quickly.
All right. Sir, please come up. I remind you that you're still under oath.
Sure.
Thank you. Were you there when officers were talking with the defendant?
Yes, Officer Dana and I are going to speak with them.
Okay. And do you recall when the defendant was asked how far he made it into the apartment?
He stated that he inadvertently had stepped into the apartment.
Okay. Did he say how far or how much?
Not that I recall, but it was, I don't recall, it's some of you would know more what you did inadvertently stepping foot into the apartment.
Okay. And did you recall if he made any gestures to demonstrate what he did?
No.
Okay. Were you wearing any body camera that day?
Yes.
If I show you that body camera, would that help to refresh your memory?
Yes.
Okay. May I approach the witness, Judge?
Yeah. Do you know what he's going to show?
Oh, sorry. It's his body camera.
Yeah, no, we've seen all the body camera footage.
All right. Sorry. Thank you. Okay. Did seeing that help to refresh your memory?
Yes.
Okay. And did the defendant make any gestures demonstrating what he did with his foot?
He did make a stepping motion, stepping doorway.
Okay, like across the threshold. Oh, thank you. That's all.
Was that in proximity when he said he may have inadvertently stepped in?
Yes, that was during when we were talking about that.
All right.
Nothing further, Your Honor.
All right, you may step down. Thank you, sir. Any additional witnesses for the people?
No.
Closing argument.
Your Honor, I believe that we've established beyond a reasonable doubt that the defendant did enter without breaking apartment 313 at the apartment complex 4800.
What would be the requisite intent that people would need to show regarding this offense?
Judge, I think it's not a specific intent crime. I think it's more generalized intent.
Specific intent crime. But
a generalized intent to do the act, and the fact that he admitted to completing the act and Erica testified.
General intent to do what act?
To cross the threshold. If I may, Judge, the jury instruction in a home invasion case, which is very similar to this, the jury instruction for entering without permission, there's case law that says any entrance, however slight, is sufficient.
I understand.
So I think
that's not what I'm asking.
Okay. So I would say, I believe, and I would suggest to you that the intent to cross the threshold, which in this case allowed the defendant to get his statement in, to get his admonition of the Hogans into them because he wanted to
But if
tell
it's
them.
an inadvertent, you would agree that would not be the requisite intent necessary, general or otherwise.
If it's an accident, that is, I would say that's likely a defense. And I think
give me your definition of inadvertent.
Right. I think inadvertent and accident are probably co-equal in this situation.
Okay.
However, the fact that the door didn't close, and we saw how the door would close if no one's in the way, tells us that there was an intent to prevent the door from being closed, which means he meant to cross the threshold. And then, as Erica described, he put his arm sort of around the door because he wanted to tell them what he wanted to tell them, which was, I'm upset with you. Effectively, I'm mad at you, or I'm upset with you and you're making too much noise, knock it off.
Or I went to sleep.
Yep. So that's the argument, Judge.
All right. Thank you. Closing.
Keep this very brief, Your Honor. First, the defendant believes that the court identified the key issue here, which is the intent. This would be a general intent to cross the threshold. I believe his testimony is that if he did enter the apartment, it was inadvertent. He did not have the intent required to cross the threshold. I also think that the two parties are telling very different stories about the same event, and that often happens in cases like this. But I would point out some of the inconsistencies in Ms. Hogan's recitation. She first said that the defendant kind of wrestled past her and entered her apartment. And then she said that when the door was almost completely closed, he stuck his foot in. It just, as she was reciting it, none of that made sense when you saw the video of how the door closes, that he could push past her and somehow, you know, have her come around him and everything. I mean, that recitation is a much larger, almost altercation. We believe what the evidence shows is that, the defendant had encountered Ms. Hogan previously. They had been moving in, well after 10 o'clock, as late as 11 o'clock, and continuing on after 11 o'clock at night. He had a very real concern that they were going to do the same thing on the night of the 14th. He went down expecting nothing more than he had previously had with them on the prior occasion. There was no intent to do anything. He wasn't in a condition to have the kind of combativeness that Ms. Hogan described. And so the defendant would ask that the court find him not guilty.
Anything else?
I think you can see the defendant's intent when he admitted that she turned her back to him, yet he wanted to make sure that they effectively got a piece of his mind. He crossed the threshold of someone else's apartment. He wouldn't leave when they clearly said, go away. I think that's what I'm guilty.
All right, put some stand in brief recess. I'll come back to my decision.
All right. 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable. Thank you.
You may be seated. We're back on the record in case of the People versus Peat. In this case, there are renditions of what occurred that day. A couple of things are of note to the court regarding what actually leads up to the purported illegal entry. And that is that this court observed as Mr. Heed was coming up to the podium, and granted, he may have been walking different than he would have back in June, but the court finds it hard to believe that he got himself into the hallway and then passed 4 individuals in that hallway to get to that door. And the court's having a very difficult time believing that occurred. I believe what Ms. Hogan says, that all 4 of them were coming in at the same time with the last load. That makes sense. But that part of the scenario also doesn't fit with what is agreed, at least between Mr. Hogan or Ms. Hogan and Mr. Heed, that the other 3 individuals were in the apartment at the time. So trying to reconcile some of the factual development, that is the conclusion that the court came to. The issue really is, and it is a general intent crime, is what was Mr. Heed attempting to do? Mr. Heed was attempting, right or wrong, to let him know that he needed to sleep. I'm not sure that is entirely Ms. Hogan's responsibility. The notion of when she moves, when she doesn't move, that is in a lot of ways irrelevant for the court for these purposes, because it's not a noise complaint charge. That's not what this is. When one gets to the issue of illegal entry, and when one examines some of the case law regarding illegal entry, what is clear, and I think conceded by the people, is that an inadvertent or accidental entry would not constitute a crime. There would have to be some indication that the defendant's intent was to indeed enter those premises. If his intent was to make known his displeasure, that still doesn't mean that he illegally entered. The only evidence that's really before the court is that his entry into the premises may have been a step into the premises or his foot on the door. And in certain instances, that can constitute an illegal entry. In this case, however, I believe what the defendant is saying in testifying, and that is when he told the officers that he inadvertently stepped in. Inadvertently doesn't cut it for the purposes of intent to enter the premises. Quite frankly, both parties probably could have found a better way to handle this entire situation and not bring it forth this way, but it's here. It is the people's burden to show beyond a reasonable doubt that the defendant illegally entered the premises. He has to have the intent to enter the premises. It can't just be something where it is inadvertent or accidental or something along those lines. The proofs in this case, and from this court's viewing of the proofs and listening very closely to the witnesses, I can't get beyond that any entry from this gentleman who was barefoot at the time into that apartment or on that threshold was anything but inadvertent. I think his intent was to say what he wanted to say about the noise. That was it. He wasn't intending to go into that apartment. He wasn't intending to step into it. Had the door remained open and he could have just said it that way, I think that's exactly what he would have done. So for those reasons, and it being the people's burden to show beyond a reasonable doubt that the defendant committed this offense, the court will find that the people have not sustained their burden in that respect and would find that the defendant is not guilty of this charge.
Thank you.
All right. Thank you.
Defense would agree to a 2-year recommendation.
All right, Ms. Tomasic.
Thank you, Your Honor. We would like to ask the court today to adopt the joint recommendation for Mr. Woods. Your Honor, in speaking with Mr. Woods from the start of this case, he has been extremely upfront about what happened and why he did what he did. He indicated that he stole the shotgun to feed his drug addiction. Your Honor, he was going through a hard time in his life. He relapsed and he was doing whatever he could to feed his addiction, Your Honor. He does have a great support system. His mom and his grandparents are here. His mom has emailed me checking in on him. He really does have a great support system, Your Honor. And from the start of this case, he tried on multiple occasions to work with Madison Police Department to advise them where the shotgun was at. They unfortunately did come up empty-handed, but Mr. Woods from the start was very adamant and very clear on where he placed the shotgun. Unfortunately, Your Honor, it is not there, so he's not sure what happened to it, whether a friend took it, sold it, whatever happened with it. But he has tried his very best efforts to try to return that shotgun just to clear everything up. Your Honor, Mr. Woods understands his mandatory prison time with the gun specification. Him and I have talked. He's going to do whatever he can in prison to keep busy, take courses, try to see what he can do for his addiction, work for his mental health. He definitely has some mental health issues based on the mental health evaluation, Your Honor. I know they advised him to get a full mental health evaluation based on my conversations with him. He's going to do that when he does get released. So, Your Honor, we would just like to ask the court to adopt the joint recommendation today. Thank you.
Mr. Woods, what do you want to tell me before I impose sentence?
May I stand, sir?
Whatever you want.
First and foremost, I'm going to apologize to the victims, the company, community courts, and my family. I let down a lot of people in doing this. Most importantly, my 10-year-old son. He suffers from us going through this. I know that what I did was wrong. I make no excuses for anything that I've done. I'm extremely apologetic. I just plan to take the next step forward and take the right path and be a better man about it. Thank you, Your Honor.
So you took the weapon, what was it, October 1st or January, or just September 30th?
I'm not sure of the exact date, but around then, yes, sir.
September 30th. Where did you go once you took it?
I went back to a place where I was staying, a buddy's shed.
And who was that?
My friend Jeff.
Jeff who?
Godney.
And then when's the next time you saw the weapon?
Probably a day later, maybe two.
When did you lose track of this weapon?
Around that time, my judgment was very clouded. I was up for 2-3 days at a time.
Where did you intend to sell it?
To the drug dealer.
Which one?
Tim McCourt.
Where's McCourt from?
I'm actually pretty sure he's in the jail at this point in time.
Where was he living?
Painesville.
Why didn't you, so you never found McCourt to sell it to him or what?
No.
Why not?
I had no way of transportation to getting there.
So what happened to the weapon?
I honestly have no clue, sir.
Did you ask the other guy, Jeff?
Yes, that's where the police department searched his
What did he
residence.
say?
He had no clue that it was even there.
Is he a drug addict?
No.
Well, so there's a 12 gauge shotgun out there roaming around by itself because of you?
Yes, sir.
Okay. Well, this nonsense has been going on with you for the upwards of 20 years now, right?
I had a previous record. I got in trouble in 2009.
Well, you got something going back to February of 07, so 19 years.
Yeah.
07, 08, 08, 09, first time as an adult. One felony, 2 felony, 3 felony, 4 felony. Theft and burglary, you're a thief, right?
Yes.
Because of what, why are you a thief?
I have a drug addiction.
Okay, what have you done about your drug addiction?
I was clean for quite some time.
How long were you clean?
From the time I got out of prison up until probably, if I had put a date on it.
When did you get out of prison?
2013.
Okay.
So, I mean, it was years.
Well, then, but until when? 2019? Is that when you started up again, or?
Yeah, around the time some significant things happened in my life.
Like what?
Things with my wife/ex-wife.
How did you, if you're being honest with me and you stay clean from, what, that's it?
That's all
Well,
the reason I needed.
Did you not have your son in 19?
I did. His mother decided to up and leave us.
When did she leave?
2019, 2019. That's when she took him, actually.
Took him where?
She left with both the kids.
Where is she? Where are the kids now?
My son lives with my mom.
Okay. When did he start to live with your mom?
Earlier, I want to say July of last year.
July of 25?
Yeah.
So from 19 until July of 25, you were roaming around using drugs, stealing?
Not all the time, no.
What were you doing the other times?
I don't know.
Were you working?
Yes.
What'd you do with your money? Buy drugs?
That and provided for my family, yes.
So once your son came back and was with your mom in July, why didn't that?
Oh, no, he wasn't gone that long.
Well, where was he?
He was with me the entire time.
Okay, so if he's with you the entire time, why are you using drugs?
I can't explain that. I can tell you something, but it would sound more like me giving an excuse. But it is because my wife decided to up and leave her family, abandon her son multiple times.
Well, so what? Are you ever gonna get over it, or it's just gonna keep going on?
Oh, I'm definitely over it now.
Okay, when did you get over it?
When she decided to start dating one of my best friends. And when she decided to abandon my son again.
When was that?
September of last year.
That was before you stole the shotgun.
Yeah, right before, like literally.
What kind of drugs were you using back when this occurred?
The shotgun incident?
Yeah.
Methamphetamines.
Where were you getting the meth?
Tim McCourt.
Have you talked to him over in the jail?
No.
Have you seen him over in the jail?
No, he was one of my wife's mom's friends.
How do you know he's over there?
Because I know he got arrested a couple days beforehand.
Beforehand, before what?
Possession of.
No, when? When did he get arrested?
I don't know the exact date.
Like when? Yesterday? A month ago? 6 months ago? What?
Oh, September.
Okay. How did you know that?
Sarah, my wife, told me.
Why were you talking to her? She took off 6 years ago. Why are you talking to her?
That's a good question. That's what my family always asks me too.
Okay. That's fine, but why are you talking to her?
Right now?
No. You found out that the drug dealer got arrested back in September. Why were you talking to her in September?
I was probably venting about what she was doing.
Yeah. What did that do for you, venting about what she was doing?
Absolutely nothing.
When are you going to change the way you've been living?
October 10th of last year is when I decided to change the way I'm living.
And so you've been locked up since then, right?
Yes.
You're going to be locked up some more.
Yes.
What are you going to do about it?
I do everything I can. I definitely.
That phrase is absolutely worthless. I didn't ask you how much you were going to do. I asked you what you were going to do.
I definitely need some mental health treatment. I need counseling to talk about my issues or PTSD, whatever you consider it has to do.
Have you been diagnosed with some mental health conditions?
Yes.
What?
Depression, anxiety.
When were you diagnosed with those things?
2023, I want to say.
What treatment did you undergo?
I haven't underwent any.
Why not?
Just never thought it was that
Because
important.
you like the drugs better than the mental health treatment. That's
Yes.
why, right?
Yes.
Okay. So, have you done any drugs since you've been in the jail?
No.
Well, that's good. Now, go back to September 30th, your thought process September 30th, and compare it to your thought process now. Which thought process is better?
My thought process now.
Okay. Which thought process was better, September 30th or between 13 and 19, if you're being honest with me?
Between 13 and 19.
When you tell me you weren't using drugs,
Yes.
which thought process was better?
My thought process between 13 and 19.
Okay. So you know what's on both sides, right?
Yes, sir.
You know exactly what it's like when you're using, which caused a shotgun to be running around out there. Okay. You know what it's like when you're not using.
Yes, sir.
So when you get out, and boy, you're going to have the opportunity to use a lot of drugs when you're in prison. You're going to find it's as accessible as it is out here in prison.
Yes.
You're going to have to decide what you want to do. Nobody's going to be standing over you holding your hand. Just like out here, nobody was holding your hand, right? You were doing whatever you wanted to do.
Yes, sir.
Now, you can't get it over here, okay? So you haven't used it. You can get it where you're going really easily. But you're 35 now?
Yes, sir.
You decide how you want to live. And then when you get out, if you do the right thing while you're there, then you'll be able to continue on the road of clear thinking. Or you can go back to being a thief and a drug addict and hanging around that goof, whatever his name is over there. It's up to you, Mr. Knopf.
Thank you, Your Honor. The defendant does have multiple prior felony convictions. He has been to prison at least one other time and has one prison number. He does have a history of juvenile adjudications. It does seem most of these cases resolve around theft offenses. He did make efforts, it seems, to retrieve the firearm. He did lead the sheriffs out there and Madison PD and his mother as well. So I do believe that those were made in good faith. The state would ask that the court adopt the joint recommendation.
All right, I've reviewed the pre-sentence report, victim impact statement, letters in support of Mr. Woods. I've listened to Mr. Woods. I've listened to counsel. I've considered all the provisions in 29, 29, 11, 12, and 13. I'm going to adopt the joint recommendation of counsel. On the firearm specification, I'm going to serve a sentence of 1 year. On the theft charge, also a sentence of 12 months. That sentence will be served after the firearm specification. The firearm specification is a mandatory 1 year term of incarceration that is served prior to and consecutive to the underlying offense. So you're going to serve a total of 2 years, credit for 112 days. When you get out, you might be on post-release control for up to 2 years under the parole authority with conditions. If you violate the conditions, the parole authority could send you back to prison for up to 9 months for each of your violations, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which would be the greater of 12 months or the time left under post-release control. You're going to pay restitution to Family Farm and Home in the amount of $480, and you're going to pay the cost. Anything further, Mr. Knopf?
No, Your Honor. Thank you.
Ms. Tomaszek?
No, Your Honor. Thank you.
All right. Good luck, Mr. Woods. We're adjourned.
Thank you, sir.
All right.
All right. This is Cody Wheeler, 25-168. Final hearing on the violation of community control violation, submitted a urine screen positive for marijuana and Suboxone December 12th. You understand that charge?
Yes.
Failed to report November 17th or thereafter. You understand that charge?
Yes.
discharged from Lake House against staff advice November 14th. Do you understand that charge?
Yes.
Mr. Fatika?
Good morning, Your Honor. I anticipate that Mr. Wheeler is going to accept responsibility for his misconduct here, waive his final hearing. We'd like to resolve the violation today.
All right, is that what you want to do?
Yes.
What's your plea to those charges?
Guilty.
Accept your guilty plea and find you guilty. Mr. Fatika?
Your Honor, Mr. Wheeler's significant other is pregnant. She's undergoing a difficult pregnancy. He left Lake House to attend one of her medical appointments. If released, he does have a job at a restaurant. He has 50 days in on this violation, 275 days credit total. We understand that there's an APA hold. I'm not sure that anything's going to happen with that. This is an F5. We'd ask that the court can consider a reasonable resolution.
All right, Mr. Wheeler, anything you want to tell me?
Just that I don't deny I obviously don't deny leaving. It was a stupid decision made over something that I rationalized to myself just for the sake of my family. I apologize for not thinking it through. It was kind of a rash and impulsive decision. I just hope that I can make it home before the birth of my son and continue staying sober and doing what I need to do for my family.
All right, gone back and reviewed the pre-sentence report, considered what counsel said, 11 months in prison with credit for 275 days, and the costs are assessed. So you'll be out in about 60 days. My guess is the parole authority's not going to do anything with you since you got this sentence. So then you'll be free of having to have anybody looking over your shoulder, and you can decide how you want to live. Anything else, Mr. Fatika?
No, thank you, Your Honor.
And that is how the cookie crumbles on this Saturday. Very, very long weekend review. Ladies and gentlemen, I'm your lone wolf Usul, and I'm tired. That was a lot. Man, imagine being kidnapped for doing lawn work because somebody was upset that you didn't haul off enough dirt. Imagine any of that crazy stuff going on. Imagine moving into your house and some crazy neighbor from either down the hall or upstairs or somewhere comes, "You darn kids need to stop your grab acid and keep it down and stay off my lawn." It's all nuts. Everybody, just outrageous behavior everywhere. Everybody needs to calm down. Be happy. Take a chill pill. Let everything wash over you. It's not an immediate response situation in most situations are not immediate response situations. So just hang out. Do like we do in the court gallery. Hang out. Check things out. Talk about things. And more than anything, come by and hang out with the Wolf at 8 p.m. Central Time, 9 p.m. Eastern Time, every single night of the week, where we watch court cases of the day. And we see more stuff just like this. We do it a couple hours every single night. At least I try to. I don't know how much longer I can keep on going like this, but I'm gonna go as long as I can. And for now, ladies and gentlemen, I am your humble servant, your lone wolf Usul, your curator for these here videos, and your host here at the Court Gallery channel. And for now, I'm going to say adieu I am out. See you later. It's cold. Expectation is the seed of all heartache. Get out of here. There's nothing else. I'm not doing a Ferris Bueller's Day Off. Don't